는 동시 통역이 제공되고 있습니다. 한국어는 1번, 영어는 2번에 채널을 맞춰 주시기 바랍니다. Simultaneous interpretation is provided for the conference. Channel 1 is for Korean and Channel 2 is for English. 2024년 국제 특허법원 컨퍼런스는 온 오프라인으로 개최됩니다. 모든 행사는 조희대 대법원장님께서 입장하고 계십니다.
The Chief Justice of the Supreme Court is entering the venue. Please welcome him with warm round of applause.
본 행사에는 동시 통역이 제공되고 있습니다. 한국어는 1번, 영어는 2번의 채널을 맞춰 주시기 바랍니다. Simultaneous interpretation is provided for the conference. Channel 1 is for Korean, Channel 2 is for English. Simultaneous interpretation is provided for the conference. Channel 1 is for Korean and Channel 2 is for English. 여러분 안녕하십니까?
Good morning, ladies and gentlemen. Welcome to the 2024 International IP Court Conference. I'm Judge Han Ji-yoon and I'm going to be the MC for today. This is the 10th anniversary of this conference, and I'm honored to be with you in this auspicious occasion. So we will start the opening ceremony for this conference. 2024 International IP Court Conference is a gathering of the judges and experts on IP area from around the world, and is being organized to promote mutual understanding. We have invited 12 judges as well as from 7 countries, as well as the judges and practitioners in the justice area of Korea. Please understand that we cannot interest everyone due to time constraints, but I'd like to thank everyone for being with us today. First, we'll start off by the opening ceremony of Honorable Chief Judge Jin Sung-chul of High Court of Korea. Please welcome him with warm round of applause. Good morning, ladies and gentlemen. First, let me extend my warmest welcome to all of you to the 2024 International IP Court Conference. I will first of all like to express my deepest gratitude to the Honorable Chief Justice of the Supreme Court for his active support of this event and for taking time to attend in person. Since its start in 2015, this conference is now its 10th edition. It has established itself as a global forum for in-depth discussions on key issues in the field of intellectual property, bringing together esteemed judges and experts from around the world. This year, as we enter a transformative period of rapid advances in artificial intelligence and biotechnology, we'll take the opportunity to discuss new and important topics in the field of IP based on deep reflections on science, technology, and law, and to explore the desirable direction of specialized courts for IP. The topics of the sessions are as follows. Session 1 will explore the factors that influence the choice of forum in international intellectual property disputes. In session 2, we'll examine the theories and practices of countries in providing substantive protection for patent rights from doctrine of equivalence. Session 3 will address the latest issues in the context of pharmaceutical and biotechnology inventions, which has become more prominent in the post-COVID-19 era, while Session 4 will compare national practice to identify areas for improvement in efficient administration proceedings. Session 5 will discuss key issues in the rapid developing field of AI and how it can be utilized in the judiciary. This year in particular, we are going to view trials from judicial specialists, not from prospective judges, and discuss how an ideal trial would look like. The conference will bring together IP lawyers from the European United Patent Court as well as courts in Korea, US, United Kingdom, Germany, Japan, China, and Singapore and other countries. I would like to express my deepest gratitude to the moderators and presenters of the sessions for their efforts in organizing this conference. Finally, I would like to wish everyone an enjoyable and fruitful conference and wish you all the good health and happiness. Thank you very much. Thank you very much.
다음은 대한민국 법원의 조희대 대법원
I would like to ask the Chief Justice of the Supreme Court of Korea to give a congratulatory speech. Please give him a warm round of welcome. Distinguished guests, I extend my sincere congratulations to the 10th International IP Court Conference on behalf of all the members of Korean judiciary. My deep gratitude also goes to Chief Judge Jin Sung-chul and all those members whose efforts have led to a successful launch of this conference, and also a warm welcome to IP judges and experts joining us from all around the world. This year marks the 10th International IP Court Conference. Since its inception in 2015, it has served as a key platform for communication, bringing together IP judges and experts from around the world to share insights and experiences. This gathering also holds great significance for the advancement of IP laws globally. And this year, we are honored to host more IP law experts, both domestic and international, than ever before, adding even greater value to this event. Today, technological advancements based on cutting-edge information and knowledge significantly influence society as a whole. Therefore, information and knowledge have emerged as critical sources of competitive advantage, and IP rights have taken on unprecedented importance. Correspondingly, IP disputes have surged worldwide, with their nature and processes growing ever more complicated. To effectively resolve these disputes, we need insights into the core of the technology involved, which requires a deep understanding of science and technology. And careful consideration is also required of IP laws, other relevant laws, and comparative law studies. The IP experts and judges around the world, I hope that they will be able to have insightful and thoughtful discussions today and tomorrow, so that we can contribute to the development of the IP field. And I hope to see fruitful outcomes from this conference. I believe that all the IP judges and experts gathered here today will forge lasting friendships and connections, sharing thoughts and fellowship beyond borders. Looking ahead, I envision the International IP Court Conference continues to flourish as a platform for ongoing dialogue and collaboration among IP judges across the globe. Lastly, I offer my warmest congratulations once again on the successful launch of this conference, and I wish each and every one of you all the happiness and good health. And to our esteemed international guests, hope you savor your time in Korea, immersing yourself in the full beauty of our autumn. Thank you very much.
감사드립니다. 다시 한번 큰 박수
Thank you.
부탁드리겠습니다.
Once again, please give him a big round of applause.
이것으로 2024년
This marks the opening of the 2024 International IP Court Conference.
시작하기 전에
And before we begin the session, we would like to have a group photo,
귀빈 사진 촬영이 있겠습니다.
and we will take the photo of the
대법관
esteemed
그리고
guests.
참가자들께서는
So, international guests and the Chief Justice of the Supreme Court of Korea, Jo Hee-dae, and also Chief Judge of the IP High Court of Korea, Jin Sung-chul, please come to the stage.
예. 준비되셨으면 카메라를 바라봐 주시기 바랍니다.
Please look to the camera.
카메라. 그리고 하나, 둘, 셋 하면 촬영을 하겠습니다. I'll take the picture on the count of 3. 1, 2, 3. 다시 한번 촬영하겠습니다. 다음으로 특허법원 법관을 비롯한 법관 여러분들 함께 촬영하시겠습니다. 모두 앞으로 나와 주시기 바랍니다.
I would like to ask the judges, participants, to come to the front to take the group photo together.
예, 마지막 3열까지 서주시면 되겠습니다. 이상으로 기념사진 촬영을 마무리하도록 하겠습니다. 앞으로 20분간 자리를 정리하고
So we will have 20-minute
11시 50분에
break
이 자리에서
and we will resume the session at 10:50 and we will hear the keynote speech. Then, thank you.
죄송해요. 제가 좀 전에 잘못 말씀드렸는데
Sorry, I gave you a wrong time. We will start at 10:50 a.m.
계속 내려. 됐어, 잘했어.
잠시 안내 말씀드리겠습니다. 행사장 입구에 변호사, 변리사, 연수 데스크가 준비되어 있습니다. 혹시 입장 시 서명을 하지 않으신 분께서는 지금이라도 연수 데스크에 가셔서 입실 명부에 서명을 해주시기 바랍니다.
네, 맞습니다. 그거를 다 말씀을 드려야 될 거라고 봐서 어디부터 주려고 할까요? 팀장님 이거 안 들리세요? 의전이 안 내.
근데 그거 완전히 없애긴 힘들어요. 기타 그거 완전히 없애긴 힘들어. 아주 조금 남긴 할 거야.
장내에 계신 여러분, 곧 노태학 대법관님께서
Ladies and
기조
gentlemen,
연설을
we will
해주시겠습니다.
soon resume our conference. I'd like to ask everyone to take your seats. Thank you.
We will begin keynote from Justice Tae-ak soon. We kindly request all participants to enter the conference room and take your seat now.
연설하실 때
계실 때. 됐을까요? 다시 한번 말씀드립니다. 곧 노태학 대법관님께서 기조 연설을 해주시겠습니다. 장외에 계신 분은 입장하셔서 착석해 주시기 바랍니다. Keynote from Justice Tae-ak will begin soon. We kindly request all participants to enter the conference room and take your seats now. 지금부터
Ladies and gentlemen, we would like to invite Honorable Justice Tae-ak of the Supreme Court of Korea to deliver his keynote presentation based on his in-depth international experience. He's going to share his experience and knowledge through his keynote speech. Please welcome him with a round of applause.
Good morning, ladies and gentlemen. It's a great honor to be here and privilege to speak this kind of opportunity. Without further ado, let me get started. It's about new approach to international dispute resolutions. To be a little more specific, implementing predictable and trusted procedural justice. International dispute, as defined by Article 2, the Act of Private International Law of Korea, typically involve dispute with foreign elements in a party or a case in dispute. Areas requiring international dispute resolution mainly include commercial matters and intellectual property disputes. Commercial matters primarily involve matters governed by Lex Mercatoria, as you know, merchant law. Your party's autonomy is strictly observed, focusing on legal relationships that parties can dispose of at their discretion. These disputes typically involve contractual relationship, but may also extend to liability for unlawful act arising from contract. On the other hand, international intellectual property disputes present different challenges. In other words, international intellectual property disputes and their resolution procedures necessitate a unified interpretation and handling to prevent contradiction and mutual undermining of judgment, particularly given to the PCT, as you know, Patent Cooperation Treaty, international application and the nature of the Internet, which raises issues regarding the validity and infringement of intellectual property rights across multiple jurisdictions. Moreover, considering the jurisdictional complexities associated with exclusive jurisdiction in specific countries, especially concerning patent rights requiring legislation, different approaches are required for design the structure. Furthermore, international intellectual property disputes tend to occur in large markets where there is a noticeable trend of forum shopping, with the patentees, patent owners, as you know, filing lawsuits in courts known to render favorable judgment. Additionally, courts themselves engage in forum selling, actively promoting their jurisdictions to attract such cases. In addition, with increase in NPE, in other words, non-practicing entity, lawsuits and the involvement of litigation finance companies in IP dispute, there is a growing tendency for cases to be concentrated in court favored by patentees. This has raised concerns that fairness of the judicial system may be undermined. Please, next row. Oh, okay. In resolving international commercial disputes, arbitration is generally preferred over litigation. This preference stems from the various advantages offered by arbitration procedures, such as convenience, expedience, confidentiality, and the flexible and discretionary nature of the process, allowing for a more adaptable resolution of disputes. However, in recent times, arbitration has faced criticism due to high cost, slower than expected proceedings, doubts regarding arbitrator selection and neutrality, and the inability to appeal arbitration decisions. In light of these issues, international commercial courts aiming for swift and efficient proceedings while ensuring the availability of appeal process have garnered attention as an alternative. Courts around the world have established international commercial courts to swiftly and efficiently handle international commercial cases, as well as attract such cases to their domestic courts. Historically, the London Commercial Court, established in 1895, has been handling not just domestic, but also a significant number of international commercial cases. Following the model of the London Commercial Court, specialized courts have been established worldwide under the name of an International Commercial Court. To my knowledge, the first of these was the Dubai International Financial Center Court, DIFC Court, founded in 2005. Subsequently, other countries have established specialized courts for commercial disputes, such as Qatar, Singapore, Frankfurt, Stuttgart, Mannheim, and China, etc. For the rest, please refer to the booklet. Meanwhile, it is noteworthy to pay attention to activities of Standing International Forum Commercial Court, in short, CFOC, which began in 2016 under the leadership of former Chief Justice of United Kingdom Supreme Court, Lord Thomas. with the aim of a mutual cooperation and exchange of views among judges and practitioners from countries where international commercial courts have been established. The inaugural meeting was held in London in 2017. The Supreme Court of Korea also participated in the first full meeting held in Sydney, Australia in 2022. And I'd like to talk the establishment of the Unified Patent Court in 2023. On December 2012, 24 out of 27 European Union countries agreed to introduce the unitary patent, which would have effect across all member states. Then in June 2023, the Unified Patent Court, UPC, was established to resolve disputes arising from the unitary patent system. Currently, the UPC has jurisdiction in 17 ratifying countries, including Austria, France, Germany, and Italy, maybe Romania and Ireland. The Unified Patent Court operates with a two-tiered judicial structure, and exceptionally, it may refer matters to the Court of Justice of the European Union when there is a dispute over the interpretation and effect of union law. Before the establishment of the UPC, parties had to file lawsuits separate in individual countries where the patent had effect, increasing costs and risking inconsistent or contradictory decisions across jurisdictions. With a single having jurisdiction of unitary patent, many of these disadvantages are alleviated by addressing disputes over patent validity or infringement. However, while this brings advantage, it also raises concerns that a single lawsuit could invalidate patents registered across multiple European countries in one fell swoop. Please, next slide. Now let's look at the situation in Korea. For international trade cases, certain courts have specialized judicial divisions dedicated to handling such cases. For instance, the Seoul Central District Court of First Instance and the Seoul High Court of Appeals each operates two specialized judicial divisions, not just for cases narrowly defined as international trade dispute, but for cases involving maritime issues and the enforcement arbitral award. Since 2018, both the Intellectual Property High Court and the Seoul Central District Court have been operating international judicial divisions to allow trials in English for international intellectual property disputes. In 2016, over 40% of patent cases and involved foreign parties, leading to consistent requests for English language trials. In response, Article 622 was incorporated into the Court Organization Act on 2017. Further regulations regarding the establishment and functioning the international panels were put into effect on May 2018. The procedure involves conducting argument and witness examination in a foreign language with a simultaneous interpretation provided by the court. Translation of written submissions or evidence is not required, and translated versions of judgment written in Korean are provided. The operation of the International Judicial Division has eliminated disadvantages related to language accessibility, allowing foreigners to argue and submit documents in a foreign language and Koreans in Korean, thereby reaching reasonable and conclusions within a short time frame and at a low cost. However, the number of such cases is significantly lower than expected. Although proceedings can be conducted in a foreign language, foreign counsel do not have litigation representation right domestically. Ultimately, a domestic counsel must be appointed. In such cases, there isn't much advantage to conducting proceedings or submitting documents in English. As a solution, there should be discussions on whether to allow foreign counsel to represent parties in future cases handled by the international judicial divisions. If both the plaintiff and the defendant use English, there should be a proactive shift towards conducting proceedings in English, including using English in the judicial divisions and issuing decisions. Decision, orders, and judgment in English. A bill for the establishment of the Maritime International Commercial Court has been submitted to 21st National Assembly. While it may have some limitations due to a focus on maritime civil cases and maritime administrative cases, its jurisdiction covers not only maritime cases but also international commercial cases. The bill mainly aims to achieve expertise, speed, and internationality by introducing special cases regarding the international nature of shipping cases, especially litigation procedures, preservation measures, and enforcement. Transitional measures of establishing
네, 이제 특별법원 설립을 위한 과도기적 조치에 대해서 말씀드리고 싶습니다. 지금까지
adequately handled and the assurance of reliability in the operation of dedicated judicial division. Moving forward, it would be desirable to establish dispute resolution bodies which have regional jurisdiction with a hybrid nature combining special courts and arbitration with conciliation for the swift and efficient resolution of various international disputes. In October 2022, Japan opened a new courthouse named the Business Court, where the Intellectual Property Courts, divisions, and Tokyo District Court specialize in divisions handling commercial, bankruptcy, and intellectual property cases were relocated. In the case of Korea, it is also worth considering locating the International Trade Division of Seoul High Court and the International Division of the Intellectual Property High Court and Seoul Central District Court intensively in areas near Incheon International Airport, known worldwide for the large floating population and convenience, such as Incheon's Yeongjong Island, to handle international dispute cases. What's the things to consider for establishment of the special courts? The purpose of establishing a special court for international dispute resolution is to enhance procedural accessibility, expedited and efficient dispute resolution, and ensure trust. Below, I will examine the specific requirements necessary when designing special courts which handle international commercial disputes or intellectual property dispute cases. The first thing is enhancing procedural accessibility and convenience. The importance of utilization of online conference have increased due to the pandemic, ironically, leading to the expansion of video trials or online trials. Discussions were made at fourth CFOC conference in 2022, focused on implementing a digital judicial system where all procedures are carried out online, from case filing, as you know, e-filing, to the classification, allocation, and online case management. One of the significant challenges of foreign litigation is ensuring the effectiveness of foreign judgment enforcement. Today, most countries recognize the validity of foreign judgment under certain conditions and also acknowledge their enforceability, as you know, like arbitral award under the New York Convention. Recently, there have been efforts to streamline the authentication process by adopting blockchain technology aiming to prove that judgments were made in accordance with proper procedure and thereby reduce unnecessary cost and time. Projects utilizing blockchain and smart contract for enforcement were underway to my knowledge, in Dubai DIFC code and Abu Dhabi's ADGM code. The advancement of such IT technology further enhanced the accessibility and convenience of international special code. Next, please. Additionally, there is a need for proceeding in English. In international special code, allowing representation by foreign countries to some extent is essential. This is because it gives the disputing parties the impression that they can accurately understand their dispute and have them resolved fairly and expeditiously. However, this should be considered within the limited scope regarding sovereignty issues, and it may be worthwhile to refer to policy of SICC, Singapore International Commercial Code, which requires recognition within a restricted range and a certain legislation process. The second thing is expedited and efficient dispute resolution. In the International Special Court, even for countries within the civil law tradition, there is a need to boldly introduce certain efficient pre-trial procedures known in the Anglo-American legal system, such as a pre-trial conference and the discovery and disclosure system. In international jurisdiction, clear principles for determining the applicable law and the reliable and valid enforcement of foreign judgment are required. In 2022, the Republic of Korea completely revised private international law to establish international jurisdiction principles and governing law principles that are governed by each field and internationally consistent. And courts, in practice, generally respect explicit and implicit governing law agreement between the parties. While it may be challenging to achieve direct harmonization of substantive law applied to dispute, such as with the principles of European contract law, as you know, PECA, there is a need to a certain level of international coherence in principles of international law, particularly those governing conflict of laws. To safely and efficiently handle dispute, it is preferable to conduct flexible and adaptable judicial proceedings through various procedures such as arbitration, mediation, and conciliation, rather than focusing solely on litigation process. It is noteworthy that United Nations Convention on International Settlement Agreements resulting from mediation, as you know, the Singapore Mediation Convention, was signed in December 2018. To my knowledge, Japan enacted a domestic legislation on April 21st, 2023, Act for Implementation of the Convention to give domestic enforceability to mediations concluded under the Convention. It should be noted, however, that the Convention only targets private mediation and excludes mediation by the court. So there is an area that needs to be examined more closely in comparison with domestic mediation by courts that recognize res judicata and enforceability, such as judicial settlement. The third thing, the last thing, is ensuring trust. To secure trust, diversification and specialization of judicial composition can be considered. While it is possible to constitute the court solely with a specialized domestic judge, considering appointing non-permanent foreign judge is also advisable. The appointment of foreign judges as non-permanent judges has played a significant role in the successful establishment of SICC. It is somewhat moving to note that Singapore even amended its constitution in 2015 to appoint foreign judges and retired judges as SICC judges. However, one thing I regret was that in the case of the SICC, the majority of judges are from common law countries with only a few civil law countries. As mentioned before, the International Commercial Court emerged because of disadvantages of the traditional arbitration procedures, which is concluded in a single judgment without appeals. Therefore, there is a need to establish appeal procedures for judgment for the court of first instance. Even so, while it is necessary to resolve dispute swiftly and fairly and exclude excessive cost burdens on parties, allowing unlimited opportunity for appeal may not be feasible. It is also worth considering whether the final appeal should be made to the usual Supreme Court or whether a separate adjudicative body within the International Special Court should be established. In conclusion, the recent international situation is indeed unsettling and unstable and unpredictable. The world has suffered greatly from the COVID-19 pandemic, and although the pandemic has now passed, but the war, as you know, in Ukraine and the Middle East. Under such circumstances, countries are increasingly prioritizing security and fair competition of openness, logic or economic standpoint, and seeking to resolve issues based on national interest and hegemony. Additionally, in many countries, political polarization has led to the rise of populism, resulting in deeper resistance to foreigners and foreign business. There is a growing concern that efforts to promote openness, global cooperations, and shared prosperity may lose momentum in the face of these challenges. So, the predictable and reliable judicial system based on the rule of law is required in the context of the international intellectual property dispute. Against this backdrop, some Korean judges launched the Global Dispute Resolution System, in short GDRS, research committee in May 2024, this year, to earnestly study new dispute resolution system. The purpose of this committee is to study system for implementing procedural justice that is predictable and trusted based on the rule of law, which is a universal principle in the international community. As part of this effort, the committee hosted a seminar about a month ago to discuss the current status of international IP dispute and how to address them. I hope this committee will serve as a meaningful starting point for building a new system for resolving international dispute in Korea. Before wrapping up, I would like to express my deep respect and gratitude to all the distinguished participants of 2024 International IP Court Conference. Thank you very much.
감사합니다. 귀한 시간을 내어주신 노태학 대법관님께 다시 한번
Thank you very much, Honorable Chief Justice. Now,
첫 번째 세션을 바로 시작하도록
we,
하겠습니다.
Honorable Justice, we will now reorganize the stage and start with session 1. I would like to ask everyone to stay in your seats. Before we get started, let me inform you about the booklet that you will received. You have actually prepared a special booklet for this conference. It's downloaded on the booklet on your table. You will see the presentation materials and various questions and answers that we are going to deal with in each session. It's mostly in English, but in some part we have also provided Korean translation. So please reference them to further your understanding about the proceedings of today's conference. Now, you could also use this QR code or the link that we have sent you to download the booklet on your devices. Now, I think we are almost ready to start the first session. Therefore, I'd like to ask the panelists as well as the moderator of the first session to join us on the stage. So we will start the first session of this 2024 International IP Court Conference. It will deal with the preferred forum in international IP disputes. The moderator will be Honorable High Court Judge Jae Hyun-gu of the IP High Court of Korea. Please welcome him with round of applause. Well, good morning. As introduced, I'm going to moderate this session. Same patent is being registered around the world, so we will have disputes in different countries. And of course, everybody wants to lodge lawsuit in the most favorable court of them. So we are going to look into MPEs and how to integrate patent management, as well as the trend of the forum shopping, and to understand the preferred forum of the related parties and what should be the ideal, the justice proceedings that we need to have. Let me introduce the participants in the order of the seating. First, we have High Court Judge Hae-jin Lee of the IP High Court of Korea. Next, from the UPC, we have Judge Rian Calden, second panel of the Court of Appeal at the United Patent Court of EU. Then from the U.S. side, we have Chief Administrative Law Judge Honorable Clark S. Cheney of the United States International Trade Commission, and then former Chief Judge of the U.S. Court of Appeals, Judge Landau Rader of the Federal Circuit Principal. And I think the topics that we are going to discuss in this session is in the booklet, so please refer to them. First, we will hear the background presentation from Judge Hae-jin Lee, and she has 10 minutes for the presentation. She's going to talk about preferred forum of international dispute. Good morning. As introduced, I'm High Court Judge Hae-jin Lee, and I'm going to talk about the forum in the international IP dispute. So I'm going to talk about international and regional integration movements, rising MP litigation, forum shopping and forum selling, preference of resolving dispute in single court, seeking unified conclusion, and lastly, I'll conclude with the need, discussing the need for a new and innovative IP court. Now, first, in terms of the international regional integration movement, in the EU in 2020, they adopted unitary patent system. So you have the unitary patent system covering all the EU, and to solve a united patent related dispute, they actually also established a unified patent court. So it has become a best example of the regional integration. UPC dispute will reduce cost and also allows possibility of inconsistent conflict rulings, avoiding inconsistent ruling of the different jurisdictions. However, there are also disadvantages because if you lose, it could invalid patent registered in multiple European countries. So this shows from 17 to 24 the patent litigation trends involving Korean company. So as you see, after UPC, the numbers have dropped significantly to 2 or 4. In the next slide, in last June, after the UPC was opened, you will see that total 15 suits involved Korean companies. So it's not as Korean companies have not have many losses with the UPC, but as UPC is known more and they recognize its advantages, more disputes will be going from Korean company to UPC. MPC, there are two types. You have the patent assertion entities and non-PEAE. PEAE is aggressively pursue patent litigation to gain an advantage, referred to patent trolls. And they have negative impact on the innovation of activities of target firms. But there are also MPs that do not engage in the patent litigations. Now, the rise of the MP litigation actually has the issues of increased litigation costs, and to increase their own interest, they engage in forum shopping. They look for their favorable forum. And recently, a third party invested in the lawsuit and gets the revenue thereof is rising, and its cross-licensing agreement is not possible because MPEs do not produce any product. So there is an argument that it's type of technological innovation, but many academia has pros and cons opinions. Now for universities and individual inventors can be MPE because they do not engage in production. Somebody needs to buy their patent to promote invention and innovation. So only looking at the MP litigation from a negative perspective might not be the only way. Let's look at the patent litigation trends in the U.S. This is statistic based on cases. More than 3,000 cases are being handled in the U.S. and more than 50% seems to be coming from the MP. And what is notable is from 2019, so 2/3 of all the litigation involves MPEs. Now it's about U.S. Litigation involving Korean companies. Every year, about 60 to 80 litigations are being lodged involving Korean companies. Next is about Korean forum shopping and forum selling. The patent infringement occurs simultaneously in multiple countries nowadays. So patent holders choose more favorable and influential courts or jurisdictions, and that has become general trend. Recently, also courts promote favorable procedures to patent holders, encouraging plaintiffs to file lawsuits in their forums, and this is called as a forum selling. So in Korea, you can start litigation in 6 districts court, and in most companies are located in Seoul, and because most of the litigation-related attorneys are in Seoul, they preferably use the Seoul District Court. However, patent lawsuits are dealt with the IP High Court in Korea, so you cannot really do forum shopping in Korea. This slide shows that statistics the survey result of Kimpa that happened in 2022. Kimpa stands for Korea Intellectual Property Association. So you see, larger markets are preferred, like U.S. and Germany. And once the market is determined, you have to select the which justice division you want to go. You want faster process, low likelihood of patent invalidation, significant damages, and easier access to injunctive relief. For U.S., they usually go to Texas and Delaware. In Germany, I hear usually go to Düsseldorf. Next is preference for resolving disputes in single court. So in case of Korea, would it be preferred forum? No, because we have small market size, so the impact or benefit from an injunction infringement lawsuit would not be big. So they go to U.S. or Germany. They file the lawsuit there because the markets are large. This trend has become prominent since Apple versus Samsung Electronics lawsuits that goes back to 2011. So this lawsuit actually was known as smartphone war in the world. It's a very well-known case. So Apple launched lawsuits in the U.S. against Samsung Electronics, and it expanded to 50 lawsuits around the world. But the litigation cost and duration was maybe very long, so they actually settled in 2014. Except U.S. cases, all the other litigations were terminated. And then you had the Supreme Court in 2016. Dispute was settled in 2018. With this, the time, cost, and efforts related to litigation, they want to save it, so they go for single court. And this case actually showed this. After this, we have more lawsuits involving Korean companies. Fifth, it will be seeking unified conclusion. This will be also the latest trend. Davos litigation, you probably know, in 2020, around it's actually surprised the whole world. Dr. Tyler said that the Davos, his invention of AI, that argued that it has actually create a patent and applied for patent around the world. And when that was rejected, he filed a lawsuit. So in 2020, Tyler's application was rejected by its High Court, but Australian Federal Court in 2021 said ITs can be inventors. So accepted Tyler's application. Then in UK and US and Germany, in that order, rejected Tyler's application. And then in the full court of Federal Court of Australia in 2022, overturned lower court decision. Instead, South Korea and Japan court also rejected Tyler's application. So Davos case, of course, there were some difference of opinion, but the court around the world referenced the other cases' judgment and showed the reasonable conclusion can be drawn up if uniform conclusion might have been available, in my opinion, if we only used one court. But anyways, let's look at the new innovative IP court and its need. IP, this, of course, simultaneously worldwide require unified resolution. And then we also need a new dispute resolution mechanism because of the geographic boundary collapsing due to internet, IP, metaverse, etc. And there's a demand for court with large jurisdictions that are neutral and predictable and provide legal certainty. In my opinion, UPC-like new court would also be possible in Asia. Now, in 2020, in November, Asian 10 countries and 5 non-Asian countries signed their treaty for cooperation. So maybe it might be a long way, but there would be a time where we could see the birth of Asian United Intellectual Property Accord. Thank you very much.
Thank you, Judge Lee. And next, I would like to ask Judge Rhian Calden to deliver her speech on the background story of the UPC's establishment and the strength of it. And the presentation time is 9 minutes. Please go ahead.
Thank you so much. So let me first explain a bit why the UPC was set up. So European, the word European has many meanings, unfortunately. So European patents are granted in a centralized procedure by the European Patent Office. But European here means countries that are party to the European Patent Convention. So a European patent could be validated in one of those 38 contracting member states of this convention. And these countries include all 27 European Union member states and 11 non-European Union. The Unified Patent Court is not a European Union institution. It's a cooperation between 18 countries within the European Union. So I'm sorry about this, it's a bit confusing, but it's good to know as a background. Now, each European patent, once it's granted, only has effect as a national patent in each EPC member state. And as said by Justice Tae-ak, in most of the cases, a European patent, therefore, can only be enforced on a state-by-state basis. And as a principle of territoriality, it's the member state of the country where the patent is validated and registered that can deal with the validity issues. And as a complication in the European Union countries that are bound by the Brussels regulation, this also involves cases where an infringement defense is raised. So basically, in Europe, patents are very much national rights and also litigated on a very national basis. Now, for these 18 countries within the European Union that cooperate, they have set up one court that deals with their 18 territories at the same time. And this court can deal with the European patents with unitary effect. And that is a new type of patent that will basically validate your patent at once for all these 18 countries at a lower price. And also European patents can be dealt with by the UPC. Now, during the first 7 years, there is a transitional period during which the UPC has jurisdiction for infringement and validity, but the national courts of these 18 countries have that as well. So there is parallel litigation during this period. And patentees who don't like the system or would like first see how the system works out can opt out from the system. So now we have basically 3 tiers. So with unitary patents, you can only go to the UPC. With European patents that have been opted out, you can only go to the national courts. And for all the other European patents, you can go to both courts. And in case there is conflicting patent cases pending, both before a national court and the UPC, we have the Brussels regulation with lis pendens rules, which basically means the court that is first seized gets to do the case, and the case that was pending at a later stage has to be stayed. There is also another parallel litigation between the UPC invalidity proceedings and the EPO, where the patent is applied for. So if there is still opposition and appeal of this prosecution stage pending, you can already start your litigation before the UPC. Now, this has 2 consequences. Before the EPO, you can ask for accelerated proceedings in the prosecution, and before the UPC, you may request for a stay of proceedings until the EPO has made a decision. But I should say the UPC is not likely to do this very quickly. So far, it has been said that the UPC will do this only if it will not cause a substantial delay. And substantial is not a very long time, because proceedings before the UPC are quick anyway. So what you learn from this is that outside CMS territory, there is not necessarily that much of an impact on proceedings before national courts because of the territoriality. Except maybe that traditionally in Europe there's been much parallel litigation, but certainly not in all countries. So what you see and saw is that litigation is quite often going on in large markets and strong patent countries, which means usually the UK, Germany, and then one or two other countries from the Netherlands, Spain, France, maybe Italy. And then on the basis of the outcome of those cases, the case gets settled for the rest of Europe. And that, I think, will continue to be the case, except that now it is more likely that the choice will be made to litigate before the UPC, because then you have 19 countries at once. Add to this the UK, and then you settle for the rest of it. That would actually be my prediction. But I don't see a trend to limit necessarily to one forum, as was just said, because I think that is very much in the framework of SEP cases, where you can see whether there is a global interest, of course, in license setting. But in pharma cases, we very much still see much parallel litigation going on. And you can see this, for instance, from the Pixibon case that really went all over Europe. Now, to finish off on a few of the advantages, so why would you go to the UPC rather than to a national court? First of all, it's cheaper if you choose more than 2 countries, and you have 18 countries at the same time. The downside of this, of course, is that you also have the risk of invalidity in 18 at the same time. So this is not the form for weak patents. But if you have a strong patent, this is certainly the place to go. Now, as to the rules of procedure, we have tried to set up the best of both worlds, combining civil law aspects with common law, which is, thank you to the UK, they were originally to participate in this project. So we took along common law principles as well. So now we have a very front-loaded written phase combined with a hearing where we allow experts and witnesses to be heard and, if necessary, also cross-examined. Not like in the high court cases, like for 3 weeks, but at least some hearing will be possible. The court will be cost-efficient and also quick. It's envisaged that decisions will be ready for within a year or so. And in relation to non-practicing entities, it's quite important, I think, other than in the US, we have a system of cost shifting. So the unsuccessful party has to bear the cost of the successful party. And in addition to this, the defendant may request that the claimant provides a security for cost of the proceedings. So that certainly prevents reckless proceedings by non-practicing entities. Now, as to this security of cost, I'm not sure where we are with the slides anyway. Yeah, there we go. We said it's discretionary power of the court. The criterion is there is a reason to order security if the financial position of the claimant gives rise to a legitimate concern that the costs will not be recoverable or it cannot be enforced. And the burden of substantiation of proof is on the defendant, but if the defendant has all the public available information on the table, and on the basis of this information there is a real concern that there is no sufficient fund of this company to be reimbursed for any costs, then it will fall upon the claimant to challenge the facts and also to provide additional information to show that it does have sufficient funds. And therefore, because that's the information that is actually only within the claimant's control. And normally, the assets of such a company, a non-practicing entity as we know it in the US, is usually only the patent portfolio. And that, the Court of Appeals just said, is not sufficient because, I mean, that's the whole thing. If the patent is invoked or if there's no infringement, then of course that will lower the value of the portfolio to almost zero, and that will then not be sufficient security. Then finally, there may be a defense it's quite often run and said, well, if we have to put up security for a cost decision in advance, that may basically interfere with our right to an effective remedy and to go to court. But that was denied because the court said, well, sufficient financial funding, not just for you to start litigating, but also to cover, if necessary, a cost decision is an appropriate financial funding of your business model, and therefore the obligation to provide the security for cost cannot be considered to be an additional burden that hinders access to justice. So that's, I think, a reason why NPs have not come to our court as much as was feared by some. Well, I think it's actually one of the advantages of our court to provide this sort of reasonable balance between the two. As other advantages of our court, I would only like to mention that in all local divisions, the use of English is possible. We are setting up a patent mediation and arbitration center alongside the court. It can be used in cases that are appropriate for such dispute resolution. And finally, we do have the possibility for video hearings. But I must say, as a general principle, cases under substance are heard on site. And although during the pandemic it has proven very useful to have video hearings, my personal preference, and alongside my preference, also the preference of many judges in our court, is that substantive hearings are heard on site. And I'd like to leave it at this.
네, 감사합니다. 칼덴 판사님. 칼덴 판사님.
Thank you very much on this presentation. Maybe Mr. Lader and Judge Cheney, I do have a common question to two of you. First, had the establishment of the UPC any impact on the forum or procedure of litigation in your country, or have there been any discussion on them? First, Judge Cheney, you have 3 minutes to answer this question.
That's a big question for 3 minutes. I am so honored to be here, and I am so honored to have been joined this morning by the justices of the High Court of Korea, honored to be with the justices and judges of the IP Court here in Korea, and with these really distinguished judges on this panel, judges that I've learned so much from throughout the years. I am here on official travel from the United States government because our government understands the importance of the relationship between our two countries. And even though the things that I will say today are my own thoughts, I wish to convey the thoughts of the commission that I work for about the importance of the relationship between our countries and between our industries. The question that was posed was about the effect of the UPC on selecting forums in our country. And so far, we haven't seen a great deal of effect. But when I go and speak to lawyers at conferences like this, they always come up to me afterward and they say, have you heard about the UPC? Do you know how fast they move? Do you know how big the market is that they can affect? And those two things are advantages that the ITC that I work for in the United States has always been known for. We've been known for speed and for controlling the access to a very large market. The market in the United States is about 330 million people, but the UPC now has the ability to issue an injunction against 300 million people in 18 countries in the UK. So it now brings some economic parity. But we'll have time to discuss these things more. I can only give 3 minutes of introduction, but I do want to say a couple of things about litigation with Korean companies at the International Trade Commission. Here where I work at the International Trade Commission, we have many investigations that are brought by Korean companies. We saw Judge Lee give a presentation about different litigation brought by Korean companies in the United States. And it's very important to us. We have many American citizens who are employed at manufacturing plants in the United States that are run by Samsung and Hyundai and Kia and LG. And these jobs are really important to our economy, and the ability to resolve disputes in a forum that is beneficial to both of our countries is very important. And I hope that we can continue to provide that, even though we have some good competition from the UPC.
네, 감사합니다.
Thank you. And I would like to ask Mr. Rader to give your answer, please.
Sure. Technology knows no boundaries.
Please turn on the microphone.
Technology knows no boundaries. That means that with a major patent or innovation, you can sue anywhere in the world. The key to international patent strategy is leverage. You want to go to the place that will give you the earliest, strongest leverage over the infringer. Now, that means that the UPC is a very influential court, and it is taking cases away from the United States because you can sue and get fast leverage from a UPC judgment. Now there's a key. You always want to file simultaneously in the US. You do not want to settle your international case in Europe. You settle your case in the US under its favorable damages law. You get better compensation when you settle the case finally in the US. But you want to obtain that settlement based on swift leverage you get more often from Asia or from the UPC. And Korea has done something very smart. They have allowed English in their Korean patent court. That means you maybe can get early leverage by coming to Korea as well. But you'll always settle in the US. And by the way, that is the key to Judge Cheney's court, too. He gives you leverage over the entire US market faster and cheaper than you can get. So you go to his court or the UPC or Korea and then settle in the US. Thank you.
다음으로 두 번째
Next, we will move the second question. And first, a question to Judge Cheney. Based on your experience with ITC, MP lawsuit in the U.S. and about forum shopping, could you maybe give us presentation? You have 9 minutes for your presentation.
Thank you. This is my first 24 hours in Korea ever. And you really know how to make a good first impression. My hotel room has this beautiful view over the Han River. And when I woke up this morning, the sun was rising over the Han River and everything was on fire with the light and the autumn colors. And it's just such a pleasure to be here. So maybe I can provide some leverage at the ITC, but I don't know that I can match the view over the Han River in the morning. The ITC has some unique features that help mitigate against NPE litigation that are built into our system. To obtain a decision at the ITC that is favorable, you have to show that you have a domestic industry in the United States. And that domestic industry standard means that you're practicing the technology in the patent and that you're making significant investments in the United States economy related to that technology. We use that phrase domestic industry, but it doesn't mean that the company that has a domestic industry needs to be headquartered in the United States. It does not. It just means that the company is expending resources that contribute to the United States economy. And that could happen in a number of ways. You could have research and development happening in Silicon Valley with engineers employed by the company. You could have a manufacturing plant in Georgia making batteries for electronic vehicles. You could have a facility where you do research on strains of botulism for Botox. All of those things can constitute a domestic industry. And so when we have a domestic industry in the United States, that's one of the elements for getting relief at the ITC. Some of you may not be familiar with the differences between the ITC and the U.S. District Courts, and I'd like to review some of those differences. As Judge Rader mentioned, the main remedy that we provide at the ITC is access to the U.S. market. If a product coming into the United States is found to be infringing a U.S. patent and that product is practiced by a domestic industry, then the ITC can issue an order that goes to each port of entry of the United States. And we have about 180 different ports of entry around the country. And that order keeps products from coming into the United States that may infringe the patent. We don't have power at the ITC to award money damages. So that's not something we do. And we don't have juries, which you might be familiar with in the U.S. District Court patent system. So those are some of the distinguishing features. Also, we have some deep expertise at the International Trade Commission. Currently, we have 6 judges, and 5 of those 6 judges have engineering degrees. All of the judges have 2 attorney advisors with engineering degrees. And so every time you have a case at the ITC, you're getting a trier of fact that has deep technical expertise available to them. About 90% of the cases we do at the ITC are patent cases, and we're having an increasing number of trade secret cases. When I started practicing at the ITC maybe 15 years ago, we had 1 trade secret case every other year. In 2022, we had 14 trade secret cases. So we're seeing a big uptick in trade secret enforcement at the ITC. And some of the reasons that we see more trade secret enforcement is because of the speed at which we can do it. At the ITC, you go to trial in about 9 months. Your trial will be in front of one of those judges that has expertise in technology. That judge will issue a decision in about 3 months. So at 12 months after filing the complaint, you'll have a decision from a judge. That decision is then reviewed by our commission. We have a bipartisan commission. It's not political. We have 3 members from each party. And that's intentional to make our tribunal neutral in terms of politics and more focused on data and economics, not on politics. Those commissioners all have attorneys that advise them that have engineering degrees. So by the time you get out of a final decision out of the ITC, about 16 different people with engineering degrees have taken a very close look at your case. And what this means is that the decisions that come out of the ITC tend not to be overturned. We have a very high affirmance rate at the Court of Appeals for the Federal Circuit. I will brag just this much and say that it is the highest affirmance rate of any tribunal that is reviewed by the Federal Circuit. That means that you can count on your decision. In fact, the judge's decision is very...
Because your opinions are so long, we don't want to read them.
They are very long. Our opinions tend to be about 300 pages long at the judge's level. So every single issue that you bring to us, we will write about it. That's very different from a district court, which gives the decision to a jury, and the jury does whatever they're going to do in a secret room and gives you a yes or no answer at the end. Any part of our decision can be reviewed and examined, and I think that's what makes it valuable in other forums around the world. You might not know that the ITC's decisions have no preclusive effect in district courts. A district court does not have to follow an ITC decision, but it's actually very rare that it departs from it because the ITC decision is very thorough.
And you go first.
And we tend to get across the finish line first. It takes about 3 years to get to trial in a district court in the United States. So we're all done with our trial around 9 months, with the judge's decision at about 12 months. The ITC also, between the judge's decision and the commission's decision, the judges are rarely overturned. So whether there's an exclusion order or not an exclusion order, which is the big picture issue, that is, once you get that decision, you can count that more likely than not it will carry through all the appellate process. And that allows parties to order their affairs in a sensible way. It also drives settlement, as Judge Rader was talking about. Once an ITC exclusion order is in effect, it really has such dramatic economic impact by closing the largest economy in the world to the infringing product, then that really drives settlement rather quickly. So those are some of the considerations that people think about when deciding to litigate at the United States International Trade Commission.
네, 감사합니다.
Thank you. With regard to the earlier presentation, I have a question to Ms. Carden. So there are, NPEs that are litigated in the UPC. How many cases are there? And is UPC a favorite court for NPEs? And as for these questions, please answer in like 3 minutes. Thank you.
Well, we don't keep statistics in terms of is this party a non-practicing entity or not. And I also should add, NPEs are generally looked at from quite a negative perspective, but I think you have to also distinguish between companies that actually sell their patents that they don't use anymore as a means of monetizing their patents in order to then subsequently fund new research. And those are not necessarily non-practicing entities in the strictest sense. So we have some very good examples in Europe, such as Ericsson, Nokia, who very much used to be in the mobile industry in the past. And they have switched their attention and they're now selling the mobile phone portfolios in order to be more focused on networks. And that allows them to invest in that area. That doesn't make them non-practicing entities per se. So where do you draw the line? I mean, you also have universities. They may apply for a patent, get one, sell it, and subsequently use the funds to have some further research done in another field. So I'm a bit hesitant in saying, well, this is a non-practicing entities and we should look at this very carefully. I think we should really only look at the ones that are, well, use this as a business model. They're very sort of low financed. There is this sort of, companies behind them that have very minimal funds given to the company to only be able to litigate. And if you lose your case, well, bad luck for you. You spend all your time in court. You're stuck with your cost of proceedings. And in this perspective, there is a tendency to settle at an early stage. Well, as said, that doesn't happen that much in the UPC because we have this security of cost. And cost shifting, and we now have this decision from the Court of Appeal saying, well, if the publicly available information is on the table and it doesn't show enough resources, then either they have to come up with, these are my assets, or they have to provide security for costs. Yes, I think we are in a more favorable position than, for instance, in the US, where you don't have the cost shifting, and they can basically, just take the risk at very low finance and force them into a settlement. So I see the time is up, but I hope this answers your question.
네, 감사합니다.
Thank you very much. Next, to Judge later, we heard about the benefits ITC from Judge Cheney. So explain factors that company consider when they choose a court of litigation between ITC and U.S. District Court. Under which circumstance do the companies prefer litigation in the ITC? So please, you have 3 minutes.
The choice of where you litigate depends upon, well, 3 major factors. First is the time it will take. The second is the expense that you will have to put out. And the third, again, is the standing of that litigation with respect to the entire international market. In that sense, when I'm advising clients, I very often say the ITC is the best place to start. We will finish in a year, not 3 or 4 years. We will expend far less. It's interesting, you have to spend that money faster, so it's expensive up front. But over a 4-year period, you will do a better job of conserving your expenses at the ITC. And if you can shut off access to the entire market, you have all the leverage you need for your international litigation wherever it's occurring. Again, you always file in the district court too, because once you've got the leverage, you want to settle using U.S. damages law. So you'll settle in the district court after winning the case at the ITC. Thank you.
Well, now you have been the head of the FCC and also worked as an attorney. So he will talk on MP litigation forms opinion. Again, 9 minutes, please.
Let me tell you an experience. Shortly after I left the bench, I was invited to a very important corporate board meeting, and the general counsel introduced me with great fanfare saying, Judge Rader will help us decide which court we should use on our important patent case. Now, he wanted to make it dramatic, so he said, how many think it will be Texas? How many think it will be Delaware? Sorry, Delaware was second, Judge Jordan. And third was California. Well, when I rose to speak, I said, it's very interesting vote that you just took, but my answer is, you should go to Dusseldorf. Now, that was before we had the UPC. I might today tell them, go to the UPC or go to maybe the Korean Patent Court, where you can still get a hearing in English. The key there is that, again, you're looking for swift leverage in an international marketplace. You can do that very effectively in the UPC, where you are likely to get a judgment inside a year. The same at Judge Cheney's court. The expense will be less, and that will give you what you need then to come back to Texas or Delaware. We'll go to Delaware, Judge Jordan, and settle using U.S. damages principles. I often teach my students in my patent law courses that this is one area where choice of court and even choice of judge really matters. By the way, that's a little strange as well here in Korea. You don't think of choosing a judge, but that becomes an important part of your strategy in the United States. You want to get before Judge Albright. You want to get before Judge Gilstrap. You want to get before Judge Jordan. And there are ways that you can choose your forum and even your judge, although that's becoming more difficult with some rules changes. But in summary, the key to international litigation is obtaining that early leverage and then using it in settlement. And NPEs, one quick point on that. You heard that 60% of the cases in the U.S. district court system are brought by non-practicing entities. There's kind of a reason for that. Most of the big competitive litigation between two equally matched competitors, most of that goes to arbitration. Why? You can pick your judges, you can pick your law, you can give a time limit. We want the judgment in 9 months, 18 months. There are just a lot of advantages to arbitration, which means that a lot of that litigation between equally matched competitors is handled in an arbitration setting rather than the district courts, and it makes it look like the majority of the litigation happening is NPE litigation. It's not. It's just that that big litigation, particularly in the biopharma sector, is happening in the arbitration forum. Thank you.
Well, thank you very much. Now, on this, let me ask this question to Judge Calden. Is there a possibility that the UPC cause forum shopping within Europe? If so, what would be the reason? Could you answer this? 3 minutes, thank you.
Well, yes, because there is no jurisdiction for the Unified Patent Court outside its own territory. So therefore forum shopping is limited to within the European, Unified Patent Court. And we do see that there is a certain preference for some local divisions within our court. There's quite a bit of litigation going on in Germany, but I think that can also be explained because Germany used to be a very strong litigation country. Most of the patent litigation in Europe went on in Germany. That continues to be the case now before the local divisions. It remains to be seen how that will work out in the future, because of course they will get very busy and loaded, and therefore it may be more attractive to go to other courts as well instead. For the rest of Europe, it's more like, as I just said, that since they're all based on European patents and the substantive law is very much harmonized within the EPC countries, there is this practice of litigating in some countries and then settle for the rest of it, and that remains, in my view, also under the present system, and I don't think the UPC as such will change that very much.
네, 감사합니다. 네.
Thank you so much. We'll move on to asking this question to Judge Cheney. The ITC is preferred by companies targeting a big market like the US, so I do believe Korean companies will prefer ITC. It is known for delivering judgment within a year and saving litigants time and cost, as you explained. But could you also explain any procedures, practice that enable this shift ruling process, and any tips to Korean companies? So 3 minutes, please.
There are 3 things I'd like to talk about that allow the ITC to resolve cases quickly. The first is meaningful deadlines. And what that means is that once we set your trial date, we're not going to move it. We're going to keep your trial date. And other deadlines in the case. We set the date that the judge is going to issue the order. We set the date that the commission is going to have their decision. So meaningful deadlines are an important part of speed. And they also allow companies to organize their litigation budgets and to plan their affairs in terms of settlement and other things. The second point that I'd like to talk about is waiver. That's what actually makes these deadlines even more meaningful. When we set a deadline to tell your contentions for infringement or to identify the prior art, we really mean it, and if you don't do it by that date, you've given up the argument, you've waived it. So that's a really important part of the way that we can achieve speed. And the third thing that we do is what I would just call active judicial involvement. All of the judges at the ITC are involved in their cases in live, or not live, but generally video teleconferences about once a month with the parties in the case. And because we're going to trial in 9 months, that doesn't go on very long before we're at trial. But those teleconferences really help to keep the case moving and to resolve disputes. And all of these things together result in what I call the phenomenon that speed begats speed. Speed leads to speed. And what I mean by that is once you have the idea that your case is going to move fast, you stop fighting about a lot of things because there's just no time to fight about them. And that helps the case move even faster. So it's kind of a cyclical effect. Those are some of the things we do at the ITC to help keep the case moving along.
Well, thank you very much. Now, that concludes all the questions, but I do have some additional questions. First, to Judge Calden, the strength of UPC. Companies seem to be concerned that a loss in litigation UPC could lead to patent invalidation across Europe. So many hesitate to bring a lawsuit to UPC. So I would like to hear your thoughts on this.
Well, yes, it's true. It's certainly true. So the positive side of the UPC is you will get one judgment that is enforceable in 18 countries. The other side of the coin is if you are met by an invalidity action, you may lose your patent in 18 countries at the same time. Now, you have to choose your chances. And we see that in some areas, especially pharma, they don't like all their eggs in one basket. So they are primarily opting out their patents. There is a bit of a strategy behind this. They want to first observe how the UPC is working, what the judges are doing. And they may have some divisionals in our court, and then they sort of keep the main patent in the national system and have the divisional in the UPC and see what happens. And of course, if you have not such a strong patent, maybe one on a dosage regime or something, it's probably better not to have that in the UPC. Yeah, so it very much depends on this. Of course, also has its pros and cons. Yeah, in the end, they have to see where the balance is going.
네, 감사합니다.
Thank you so much. Next, to Judge Cheney, I have this question. Looking at the number of US IP lawsuits in 2023, it appears that these concentration of IP cases in specific courts have been somewhat eased, with the number of litigation increasing not only in the Western and Eastern District of Texas, but also in Delaware and California. So, what do you think are the reasons for this change?
That's a good question. I want to follow up on something that the question posed to Judge Calden. It seems to me that if your patent is invalid, that your reasons for not wanting to assert it are that's the sunk cost fallacy. You don't want to assert it because you don't want to find out it's invalid, but if it's invalid, you can't assert it anyway. So you might as well assert it and see what happens. But in terms of the distribution of cases around various forums in the United States, in 2017, our Supreme Court decided a case called TC Heartland, and it changed the standard that district courts look at to determine if venue is proper for a particular lawsuit. So that was a big change that helped distribute cases differently in the United States. And then we had another change that one of the chief judges in Texas decided that instead of having patent cases go to a particular judge, that they would be assigned to various judges in that district on a rotating basis. And that took some pressure off of intensity to file and obtain a specific judge in Texas. So it seems that our Supreme Court is concerned about judge shopping and forum shopping in the United States, and that some measures have been taken to deal with that. At the ITC, we have a law that specifies how cases will be assigned. It says that the cases will be assigned to judges in rotation as far as is practicable, so that helps prevent forum shopping. There was a time at the ITC when we had a judge that was famous for finding every single patent that came in front of him to be invalid. And because we assigned cases on this rotating basis, when this judge was the next one in the rotation, all of the couriers would stand in front of the building with their complaints. The couriers that were working for law firms that were in the know. And then some uninitiated law firm would come and file their complaint, and they would get this judge, and then all the other couriers would quickly try to get the next 5 judges before that judge was up again. So we instituted almost all of our investigations in a matter of an hour at various times. We don't have that system at all anymore. We don't have judges that are known for that kind of behavior anymore. In fact, the ITC is very transparent about statistics about winners and losers. They're all published on our website, so you can see what happens. We also have software or web-based services in the United States where you can look at a judge's record and see if they're in harmony with averages, and so those things are helpful when making litigation decisions.
Well, thank you very much. Now we will go to later which courts in the U.S. tend to favor patent holders and what might be the reason behind this preference. So conversely, are there courts preferred by opposing parties and why?
Well, this would be a somewhat controversial topic, but I think there's a general sense that the thing you look at to determine the benefit of going to a particular judge is their summary judgment rate. How often do they dispose of a case before going to trial? That becomes very important for a defendant who wants to hopefully invalidate the patent or avoid infringement before having to bear the expense of trial. Again, there are lots of statistics on this that you can follow. The lowest courts for summary judgment rate are in Texas. The Texas judges just believe you should have a trial. They do not grant summary judgment kind of as a matter of Southern gentlemanly principle, I guess. The highest summary judgment rates tend to be in California, where the Northern, Central, and Southern District have generally quite high summary judgment rates, terminating the trial before you, terminating the case before you get to trial. So based on those summary judgment rates, Texas tends to be favored by plaintiffs, California by defendants.
그리고 이혜진 판사님께 질문.
Now I have a question.
기업들이 유리한 재판지를 찾아서
Companies may strategically select favorable courts based on time and cost consideration. Could you elaborate on why you think a new court with unified jurisdiction? Well, yes. Companies trying to find favorable formula, of course, is necessary in terms of cost or time. UPC, ITC, or California, Texas district courts. How many company can seek them out? I think MPEs, or if you have a large company with your own legal team, you can do that. But if you have startups or small SMEs, if you have international patent litigation, it could even impact the survival of your business. So IP is becoming global, but each jurisdiction have different rules and procedures. So you might be from. So you have the also issue of the entry barriers. IP issue happens in multiple locations around the world. Hence, it becomes burdensome in terms of cost and time for parties involved. But what if you have neutral and predictable judgment available? I think you can then dedicate your time and cost more on R&D rather than fighting in court. And that's why I think unified jurisdiction and court would be possible and needed. It is already there for US and Europe, but what about Asia? I think you could also have another UPC for Asian market. Thank you. Well, that concludes all the discussions that we had. But from the floor, if you have any questions, we'll be more than happy to entertain them. So if you have a question, please state your name and where you belong to and to whom you're asking the question to. So if there's any questions, please. Now, if you have raised their hands. So maybe Judge Kumbon, you could go first.
I'm Judge Boong-kwon, serving at IP High Court of Korea. Thanks for the insightful presentations of all the distinguished guests and speakers. I really learned a lot and enjoyed a lot at the same time. I want to ask a question to Honorable Judge Cheney on waiver system. I wanted to ask if this waiver system is codified in statutes, and even if so, I want to ask if you had difficulty to establish it as principle or doctrine. Like, for example, if attorneys might think that in deep down they might trust judges would give some sort of leniency to that. Did you have that sort of challenge or difficulty? That was my question. Thank you.
It's a great question, and I really enjoy talking and learning from other judges at conferences like this. So at the ITC, we have a law passed by our legislature called the Administrative Procedure Act. And under that act, each judge is given authority to, this is the words of the statute, regulate the course of the proceedings. Pretty general words, but you can do a lot with those words in our system. And maybe about 15 years ago, judges at the ITC started putting out their own individual ground rules to regulate the course of the proceeding in front of that judge. And they started putting in these waiver rules. Those waiver rules have now been affirmed by the Federal Circuit in precedential opinions on a number of occasions. So it's quite well established now in US law that ITC judges can do this. It's also very well established that district court judges like my colleague who is here from Brooklyn can also find waiver for failing to provide a position or information at a certain time designated by the schedule of the case.
Thank you for the answer. And any attorneys in the room who would like to ask a question? Yes, from the same table. Yes. Judge Lee Hae-jin and Judge Tae-ak actually talked about the special court establishment and the special law related to it. So I would like to ask Judge Kelden and former Judge Rader to give us any insight about what we can learn from your experiences.
The Justice No and Judge Lee presented two important things, I believe. First, the International Tribunal, which the Korea court already established a couple of years ago, where the English language can be the formal court language and some other benefit procedurally. However, the case which was brought to the International Tribunal was not so many as we hoped and anticipated. And second important thing was based on the International Tribunal, we talked about, for example, Asia IP Court. The Korean can take some lead to establish the Asia IP Court, which covered the Asia area, like the UPC. So if both to the Honorable Judge has some advice or view on these two important issues, I'd like to hear from Judge Kelton and Judge Rader.
Well, it took Europe, in the end, only 18 of the European Union, about 50 years, so 50 years, to come up with an agreement to set up this court, which tells you how politically difficult this is. And one of the major problems we had from a political point of view was languages. And we didn't have AI for a very long time, even when it was concluded. AI had not been developed as much as it is today. So languages really was an issue, and especially also the costs of translation, interpretation, and so forth that comes with it. Now we are, well, this is my very personal opinion. But now I think we are stuck, if I may use the word, with a multi-language court, which in my view is not the most efficient court it could have been, but this was the sort of the maximum political compromise that was available at the time. And the problem with this is the difficulty of finding judges that are multilingual to deal with the cases. And I think also in Asia, I mean, English is the international language, especially when it comes to technology. So my personal advice would be to go for English as the only language. In Europe at the moment, ever since the UK decided to leave us, unfortunately, English is actually the common language that is nobody's native language, which basically puts everybody at the same level, which I think is great. And the problem, you know, with German, for instance, I mean, how many judges speak German in Europe? You know, there is an end to our resources. And so, and also for, as you said, the problem with the lawyers, if you would allow lawyers from different countries to present a case before this court, but you're still stuck with a local language, in the end, it is not really sort of international, is it? Because if you then come to Korea, you would favor the Korean judges. If you would be in Vietnam, you would favor the Vietnam attorneys. So, I mean, if you would allow them to present the case before all of the divisions, I mean, if you would only have English, that would give a similar advantage and similar disadvantage to all of them. So that would be my personal advice when you set up this court.
The question you have to ask is it worth it? You're going to have, as Judge Calden pointed out, a real difficulty coming to agreements as to how you're going to select the judges from various countries, how the judgments of an Asian IP court would be acknowledged by each of the individual countries. That's going to be a very costly and lengthy process. Is it worth it? I think there are advantages, of course, of a single court that gives you single judgment, but I think you can achieve some of those same objectives by obtaining leverage in one court or another, and then using that to settle the technology disputes worldwide. That really is the way that the system is working, and quite well. So I'm not sure you're going to find it's worth it to make the great effort to get a unified Asian IP court.
Maybe if I may add, mind you, within the European Union, we had quite a elaborated legal framework for the European Union already. So we already have the Brussels regulation for enforcement and recognition. We already have the enforcement directive on the enforcement of IP rights. We already have a very strong, strongly harmonized substantive law for European patents among Europe. And still, the setting up of this one court, was a real effort. So all of that, I think, would still need to be done among the Asian countries that you were referring to, which is, I would say, a hell of a project.
네, 감사합니다.
Thank you. And Judge Cheney, do you have anything to add?
The success of a court that's competing in the international stage depends everything on the remedy that it can provide. And the reason that I think the UPC has such promise is because it provides a remedy in such a substantial market. So that's got to be part of the calculus, is what is the size of the market for this unified court, and will that market size compete on the international stage? As Judge Rader said, the system that we have now seems to be working pretty well. In every case that I have come before me as an ITC judge, I always ask the parties, where else in the world are you litigating? Because by definition, I've got some international litigation happening because it's in my court. And they're almost always doing different things around the country with different strategic goals in mind. So even with a unified court, countries will, or litigants will try to tailor their particular litigation to their company's particular problem. And that problem may be amenable to a unified court, but it might not be. Because every company does something different and they all have different economic realities that they're dealing with.
Well, thank you so much. I think we have spent all our time up. So maybe we can get closing remarks from our panelists. So I'd like to ask Judge Lee to start with her closing remarks. Well, this is the 10th anniversary of this conference. I'd like to thank all the panelists for joining us, and as well as the audience for joining us for today's event. So from the first conference, I've been attending every conference for the last 10 years. So I could say maybe I'm kind of the protector of the IP High Court of Korea. And I also have a personal dream, more new and creating more new innovative court with the panelists and with everybody on audience. Hopefully you can all join in this effort. That's my dream. Thank you so much. Thank you very much. Judge Calden.
Well, thank you so much. I hope you found this panel as insightful as I found it. As it's always so interesting in international conferences that each time you learn from your colleagues. And that is why it is so worthwhile that these conferences are organized. So I'm very grateful to the UP IP High Court in Korea to have organized this conference. I very much look forward to the next sessions because, as said, there's always something new, even for those that travel to a lot of conferences and have these discussions. So please continue to organize these conferences and thank you so much for having me on this one.
네, 감사합니다.
Thank you very much, Judge Cheney.
In my position, I'm not only a jurist, but I'm also a trade person because we're a trade court. And about 10 years ago, I worked at the U.S. Trade Representative's office. And at that time, the United States had just completed a very important trade agreement with South Korea, which we call in the United States chorus, which is a pun because chorus is a group of people singing together. And it's also a combination of Korea and U.S. And it's just really wonderful. As I worked on that trade agreement, I read about the economic miracle. And to be here in Korea and to see that what has been accomplished and to think about the role of IP in making that happen and thinking about the unique relationship between our two countries is just a great honor for me. And I look forward to continuing our conversations at lunch and throughout the coming days. I thank you very much for allowing me to be here.
네, 감사합니다. 변호사님 부탁드립니다.
I'd like to reflect just a moment on the historical development of our technological courts. In the 80s and 90s, we saw nations such as the United States adopting a court with unique patent expertise. That spread to Korea, Japan, Vietnam, Thailand, Taiwan. That effort spread into China, and of course, there are 2 decades or 3 decades of nations learning from each other to adopt some kind of expertise within courts to handle difficult technology cases. The next 10 to 20 years brought us into a period of cooperation where the courts would work with each other and see each other and try to learn from each other how to better administer these kinds of cases. I've been a little concerned that that's dropped off over the last 5 or 10 years. That's perhaps the emphasis has shifted to the UPC, and there's great interest in seeing how that will influence the development of technology courts. But I would urge us to continue to learn from each other through cooperation and influence. Just judges knowing each other and talking to each other can advance this process. And that, I think, can elevate judicial performance, which began 30, 40 years ago, but now needs to meet the expectations of really implementing a high-quality jurisprudence in the technology area. Thank you. 감사합니다.
네, 감사합니다. 네, 이것으로 1세션
With that, we will conclude the first session. I would like to thank all the panelists for their wonderful discussion and also presentations. Well, thank you very much, and also thank you to our moderator.
곧 마치면서 1세션 참석자들 기념 촬영이
We will have a group photo session with the session's panelists.
기념
you you
저녁 때 1시간 원래 비는 시간이 있어서 그걸 줄이는 걸로. 네. 잠시 안내 말씀드리겠습니다. 당초 점심 시간이 2시에 종료될 예정이었는데요. 한 10분 정도 연장을 하겠습니다. 그래서 정리하고 2시 20분에 세션을 시작하도록 하겠습니다. The luncheon was originally scheduled to conclude at 2 o'clock, but we will extend it by approximately 20 minutes. The second session will start at 2:20. Thank you.
하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 마이크 테스트 중입니다. 하나, 둘, 셋. 하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 둘. 하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 네? 하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 셋. 하나, 둘, 셋. 안녕하세요. 하나, 둘. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 하나, 둘, 셋. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘, 셋. 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 네. 하나, 둘. 안녕하세요. 마이크 테스트 중입니다. 하나, 둘. 네.
푸시트가 없는 것까지만 돼 있네. 네. 그건 제가 한번 다시 확인해 볼게요.
잠시 후 2세션을 시작하겠습니다. 모두 자리에 착석해 주시면 감사하겠습니다. Ladies and gentlemen, we'll commence session 2 in just a few minutes. Please be seated. 다시 한번 안내드립니다. 곧 2세션을 시작하겠습니다. 모두 자리에 착석해 주시면 감사하겠습니다. Session 2 will begin soon. We kindly request all participants take a seat. Thank you. 곧 2세션을 시작하겠습니다. 2세션 참가자들께서는 무대 위로 올라와 주시면 감사하겠습니다.
We will begin the session 2 shortly. I would like to ask the panelists of session 2 to come up to the stage. Thank you.
Session 2 panelists, please come to the stage to prepare. Thank you. 즐거운 점심시간 되셨는지요?
Hope you enjoyed lunch.
이제 2024년
Now we will begin the second session of the 2024 International IP Court Conference. And in this session, we will be covering the doctrine of equivalence, approaches in different jurisdictions for substantial patent protection.
법원의 정택수 고법판사님께서 이끌어 주시겠습니다. 큰 박수 부탁드립니다.
Judge Jung Taek-soo of IP High Court of Korea will be moderating the session. Hi, thank you so much for the introduction. Nice to meet you all. I am Judge Jung. I am excited to be moderating this session. It's an honor. And the topic of this session is Doctrine of Equivalence. And this topic is such an important topic for the legal practice, and I would like to introduce our panelists for you. Please give them a big round of applause. First of all, we have Judge Amano Kenji of IP High Court of Japan. And next, we have Judge Brian Calden of the second panel of the Court of Appeal, UPC. And we have Judge Richard Mead of High Court of England and Wales. We have former Chief Justice of the US CAFC, Mr. Rendell Rader. And we have Judge Valerie Thien from High Court of Singapore. And lastly, we have Judge Kim Gi-soo from Intellectual Property High Court of Korea. Thank you. And we sometimes have to cut losses in our life, and there are things that we will need to always cut for our health and beauty in our life. What would that be? That's callous. So please give us the hypothetical case. Okay, you're looking at it right now on the screen. So we have prepared a hypothetical case. And this invention is called a callus remover with microcutters. And this hypothetical case is on a patented invention related to it. So the microcutters here are important. The feature of the microcutter is that it is shaped like a gourd. So the shape of the microcutter is specified as a gourd shape where two circular sections overlap with a concave middle. And the defendant's product has a circular shaped microcutters, which is on the right. So the left one is the patented invention, and the right one is the defendant's product. And the dark highlighted area is the cutter. So in the patented invention, there are two protruding points where the cutting begins at two locations, and there is a concave middle, right? And there you have additional cutting thanks to the shape of the microcutter. And in this hypothetical case, the gourd shape or the circular shape is used for the microcutters, and these are quite new shape for the microcutters. And if you look at the reference book in front of you, the booklet in front of you, you can find it at 117. And well, if you look at it from the paper, it's 119, page 119. So please refer to those pages when you're looking at it from the booklet. And we do have a survey for you regarding this hypothetical case. So this patented invention, do you think that the defendant's product constitutes an equivalent infringement on the plaintiff's patented invention? And if the gourd shape is the defendant's product and the circular shape is the plaintiff's product, then would the result change? So please join the survey now by using this QR code on the screen, and there you will be able to give your answers by clicking on the options that are provided on the survey form. So please click those so that we can check your views on this case. And if you change your mind in the middle of the session, you may redo it. You can cancel, withdraw your answer, and re-answer. And at the end of the session, I will ask the same questions to the panelists as well. And you don't have to feel pressured because I'm just asking for your off-the-cuff answer. And I am very curious to see how our audience is going to view this case. And, during the session, please, feel free to answer in the survey. But there's one thing that I want to remind you. This is really only to pique your interest and get you engaged in the session after lunch. So please do not dwell on it too seriously, okay? And do not try to engage in very serious discussions amongst yourself on this hypothetical case. Then let us move on to the panelists' presentations. We have prepared 8 different questions, and the panelists have answered these 8 questions in earnest, and some of the members have prepared the presentation materials as well. And the detailed answers to these questions are already prepared in the booklet, so you may be able to refer to that at your convenience. And we will be having the session in 4 different parts, and we will be grouping 2 questions in one part. So we will be, getting the answers from Japan, UK, US, and Korea. And Judge Rian Calden and Judge Valerie Teen have prepared presentation materials. So those presentations will be put in the middle of the different parts. And before we kickstart the session, I'd like to ask our panelists for their understanding for the limited time we have. And I would like to ask for your understanding from the audience as well on that note. And I'm sure that you have questions from the floor, and those will be dealt with at the Q&A session at the end. So let me ask the part 1 question. So I'd like to ask our panelists to tell us about your respective country's equivalence test and what each element in the test means using examples or precedents. Also, please tell us if your country's equivalence test is closer to the element-by-element analysis or the invention as a whole analysis, and share any relevant cases. And you have 4 minutes each for your answers. Let me first start with Judge Kenji from Japan.
안녕하세요. 일본 판사의 아마노 켄지입니다. Okay.
I'm Amino Kenji, judge from Japan.
All right. Although we don't have any black letter law, that means statute of doctrine of equivalence, but as I described here, we have a Supreme Court case in 1998. It is greatly influenced by United States Court decision. But when the defendant product has a different part from the patented invention, when the 5 requirements are met, the defendant product will be rendered as infringement or as equivalent. The first, the difference between the claimant patent and the defendant product should not be the essential part of the invention. The secondly, the dependent product should enjoy the purpose and function and then effect of the invention. And the third, the dependent product should have been easily it would have been easy for a person of the skill in the art to conceive the idea of replacing the lacking part from the invention to make a dependent product. That's the third point. Fourth, it should not be on the public domain at the time of filing. And the fifth element, fifth requirement was no special circumstances such as kind of prosecution history estoppel. And that's the answer for the question 1. And the second question, for the second question, we have a Supreme Court case in 2016 called Max Callisto case, written in my description. But because time is limited, we are looking at the concept of the invention, not the every single element of the invention, but the total concept of the invention. So I'd like to answer whether we apply which principle we applies invention as a whole approach. That's it from now. Thank you.
네, 감사합니다. 아무나 경기 판사님.
Thank you. And next, I would like to ask Judge Richard Mead to give his answer, please.
Thank you very much. I'm honored to be here. This is my third time attending this conference, but my first time in person. And I'm delighted to be talking about such a fundamental topic to patent law, and I think also one of the most interesting topics to discuss internationally and to compare our different approaches in different jurisdictions, and also a topic that's key to balancing the interests of patentees and defendants. The UK has always considered the topic of equivalence within the law of infringement of patents, but it's only since our Supreme Court decision in the case of Actavis and Lilly, and the reference to that is given in full in the conference materials, that we have started to describe equivalence as being the subject of a truly separate doctrine. And we answer the question of whether there's infringement by equivalence as follows. First of all, we work out what the ordinary meaning of the claim is, and then having done that, we ask whether the variant infringes as an equivalent using three questions. I won't read them out in full, they're set out in the very helpful conference materials, but paraphrasing a little bit, first of all we ask, does the variant work the same way, by looking at the inventive core of the invention. Secondly, we ask whether it would be obvious to the skilled person that the variant works the same way. And thirdly, we ask whether there is some indication in the patent to indicate that the patentee intended to have a narrow claim scope rather than a broad one. And depending on the answer to those questions, we decide whether or not there is infringement by equivalence. We answer the questions claim element by claim element. In other words, it's necessary to find with respect to each element that there is either normal or equivalent infringement. But in looking at each element one at a time, we require there to be had regard to the overall inventive core of the invention. So although we look at each element one at a time, and although it's requirement that each element be found, we try to do it in a unified way with a single consistent regard to the inventive core of the invention. And we thank you for your attention. That's the UK's answer to questions 1 and 2.
네, 리차드 미드 판사님 감사합니다.
Thank you. So in the in the UK, I have a question. So after the vector-based judgment, the improver-related judgment, the big framework would be still maintained, and you're seeking the doctrine of equivalent with that as a backdrop. Is that the case?
Yes, thank you. That's a very good question. The answer is essentially yes. We've always had a three-question approach, which is almost always used, although not mandatory and not part of the statute. And previously that was in the improver questions. That was looked at by our House of Lords, our Supreme Court, in a case called Amgen, and then it was reconsidered by the Supreme Court in Actavis and Lilly, which rephrased some of the questions and reorganized the questions to give effect to a separate doctrine of equivalence. But you're absolutely right, the overall analysis is very similar to what we've had since the improver questions in the 1990s.
네, 고맙습니다.
Thank you. And I would like to ask Mr. Radar to give his answer, please.
Yes, the United States uses a rather simple, straightforward test of whether there is substantially the same function, way, and result in the equivalent as in the claimed invention. That always comes down to a question of whether it's substantially the same way. The result and function are almost always synonymous. This is found in the case of Warner Jenkinson, and we have revisited the doctrine of equivalence, looking for its fundamental underpinnings, and determined that really the one purpose it performs is to protect a claimed invention against after arising technology. If you have a new technology which changes the terms of a claim, then you can still protect the invention even though its claim terms have been changed by the after arising technology. We enforce this on an element by element basis. There's a little contradiction in that, because that asks us to look at whether there's a missing element. Well, the whole test of the doctrine of equivalence is whether there's a missing element from the claims. And so the element by element approach really performs one function in U.S. law, and that's to convert the question of doctrine of equivalence from a question of fact that the jury would look at to a question of law which the judge can decide on summary judgment. And most often it is decided on summary judgment on an element-by-element approach, finding that the way is not substantially different. Thank you.
네, 감사합니다.
Thank you. And now I would like to ask Judge Kim to give his answer. Thank you for the question. We have many people in the room, and I'm sure that you're very much familiar with the doctrine of equivalence that is applied in Korea. But we also have international panelists here and other esteemed guests here, and we are hearing from many different countries as well. So this would be a great opportunity to make comparison amongst different countries. So this would be a good chance for you to reflect on our doctrine of equivalence and maybe think about how to improve it even further. So when it comes to the DOE in Korea, as you all know, we look at the technical core and the effect, and if there are any small changes to the claims, we are preventing it from invalidating the whole patent, and the doctrine of equivalence is developed in that backdrop. So for the equivalent infringement to be constituted, you have to have the same core, and we call it the identity of the problem solving. And thirdly, changing the elements should be very clear to the Fujita, and we actually consider those three factors as the important criteria of the DOE. But if we are only looking at those three factors, then in some cases there could be cases where the protection is given to the knowledge that was already in the public domain, and there could be some cases where the claims are ignored on an unreasonable basis. So that is why it can lead to the infringement upon the rights of the third party as well. So we will need to consider those public value as well. And we will also need to consider the trust level of the third parties as well. So from those different aspects, we will need to set the right criteria. And in that sense, the DOE in Korea also include the additional factors such as it shouldn't be the free-to-use technology and it shouldn't be it shouldn't be intentionally excluded from the claims. So if the technology is already easily obtainable from the public domain, which is that it is a free-to-use technology, then it will need to be considered as a factor as well. And for the items that are intentionally excluded by the patent holder, it should be considered as part of the DOE consideration. And it is a very tricky question whether we are looking at it element by element or the invention as a whole. But the important thing here is that the patent and the changes to the elements will need to be looked at together. And if there is nothing, then there is no room for the equivalent infringement. So the equivalent level between different factors will have the room to be explained as the element by element analysis. But when it comes to the actual practice, the same identity of the problem-solving mechanism and the identity of the technology and the effect will need to be looked at together. So at the level of the way of the problem solving, we are actually looking at it from the invention as a whole. Thank you. Thank you, Mr. Kim. I should be managing the time wisely, so I should keep it to myself, but I really do have one question to Judge Amano Kenji. I mean, as you know, we have many different similar doctrines. I mean, of course, there are different legal differences, legal framework differences across different countries, but then in Japan, we do have a lot of similarities. So let me ask you this question. So when it compares to the prior art, if there is not a big contribution to the development of the technology, then it is unlikely that it will constitute a equivalent infringement. Is that the case? And if the contribution level is continuously evaluated, then before the evaluation is complete, then the dependence products detailed analysis cannot be done in advance. Isn't that the case? What do you think?
You're asking that the patented invention is little contribution to the prior public domain. What happens if the patentee argues the doctrine of equivalence? Is it okay to do that?
So, for example, in the Mikatato case, according to the doctrine that was used there, you are considering the contribution to the technological development. And before you make that evaluation, how much of the contribution there was, you cannot make a in detail analysis of the product level. Isn't that the case?
Actually, I'm not sure I just articulate your question well, but if the contribution of the invention is not high, that will make our I'm sorry, I have to think about that to answer later.
I'm sorry. 정말 죄송합니다.
I don't understand you.
이따 또 한번 같이 얘기해 보기로 하죠. 네, 그럼 감사합니다. 자, 이어서 파트 2로 넘어가겠습니다.
Okay, thank you. I mean, I'll ask you the question later, separately. And moving on to the part 2. So, what is the sequence? So, when assessing equivalence, how do your courts consider prior art? Do they, in practice, differentiate between prior art? Oh, so sorry. I mean, in the equivalence test in your jurisdiction, what is the sequence like? What is the sequence between assessing whether the effect is identical and assessing whether the problem-solving mechanism is identical? And also, do your courts consider the knowledge and skill level of a FOSITA? If so, which requirement of equivalence test is related to the FOSITA? And what is considered the relevant date of assessing such aspect?
So, Judge, from Japan, Judge Amano, you can go first, and you have 3 minutes.
Okay, the first question is is there any separate step determining the solving the problem or the result? Okay, as I explained that the first requirement we look at the inventive concept, what is the essential part of the invention. And the second step is we look at the result, function, and the effect of the dependent products enjoyed, whether the dependent product enjoyed the function and the effect of the invention. So there is a separate step, but it is closely related. So if the requirement 1 is met, usually the second requirement will also meet it. And the second question would be the relevant date. So our third requirement looks at whether the dependent product is easy to make at the time of infringement date from the patented invention. And the fourth requirement is when the time of the patent filing that the dependent product would be a public domain. So that's my answer.
네, 고맙습니다. 네, 이어서
Thank you. And I'd like to ask Judge Richard Mead, please.
Thank you very much. So in relation to question 3, the result and the way of achieving it are both considered together within question 1 of the activist and Lilly questions that I paraphrased earlier. And I respectfully agree with Judge Amano that these two are very closely related and sometimes quite difficult to distinguish. But in any event, as a matter of doctrine, we look at both of them together within activist question 1. In relation to the timing of the equivalence determination, I think this is a particularly important and interesting question in the context of the purpose of looking at infringement by equivalence. In general, in English law, we determine the meaning and validity of the patent at the date of the patent, at the date of application. But we don't apply that principle inflexibly, and it's become apparent to English and European patent law over time that trying to assess equivalence without reference to information available at the time of infringement is unfair on patentees, especially because it deprives the court of the opportunity to consider the effect of inventive improvements. So in relation to the law of equivalence, the activist questions in UK law permit the ordinary skilled person to be told that the alleged infringement, the variant, does in fact work, even if that's not information that would have been available to them at the date of the patent, and even if it's not something that they could work out for themselves using their common general knowledge at the date of the patent. And this allows, in appropriate cases, for the patentee to succeed when the equivalence question concerns technology that was only developed after the date of the patent. So the answer to question 4 is generally the time of equivalence is the date of the patent, but for inventive variants in particular, it's permissible for the person skilled in the art to be given information that's only available at the date of infringement. Thank you.
네, 미드 판사님 감사합니다.
Thank you. And I'd like to ask Judge Rader for his answer, please, from the U.S.
We are examining the accused product or process in comparison to the written claim language. And we're looking to see primarily if the accused product uses substantially the same way of solving the problems. Most often this issue gets decided in the U.S. courts based on some exceptions to the doctrine of equivalence and whether they exist. And the primary exception is prosecution history estoppel, which means if you have changed your patent by amendment during prosecution to avoid prior art, that you cannot recapture any subject matter that you surrendered during the prosecution process. So that does relate the doctrine back to prior art as we discern whether there has been any surrender of claimed subject matter which then cannot be recaptured using the doctrine of equivalence. We perform this analysis at the time of infringement. So that would come at a point later when the infringement has occurred.
감사합니다, 레이더 판사님.
Thank you. And lastly, I'd like to ask Judge Kim. Thank you for the question. Listening to the answers, I think the practice of Japanese judiciary is quite similar to the Korean one. And in Korea, we are looking at the identity of the way of the problem solving. So even though the effect is the same, if that is not based on the same problem solving, it's not going to be the identical or the equivalent one. And there are 5 different standards. There are 3 affirmative factors. These are independent standards, so we cannot really view that there are sequences between these 3 factors. But then in practice, we look at the identity of the problem solving and the identity of the effect, and we are looking at the ease of substitution. That is the sequence that we look at. And the third one, the ease of substitution, and the 4th factor, which is it shouldn't be the free-to-use technology, are important factors that we consider as well. And the ordinary skilled, for CETA's skill level, we are looking at it from a very sophisticated timing perspective, but then according to the Supreme Court ruling, it should be based on the core of the technological invention. Thank you. Thank you, Judge Kim. So I would like to, ask the audience to give our panelists a big round of applause. And when a moderator asks a question out of the blue, that would, put the panelists back, so I'm sorry about that. But I mean, DOE is such an important topic, but we get drowsy sometimes. That is why we have prepared this hypothetical case. I am sure that you have, gone into the survey screen and checked your answers, but then if you haven't, please do so by going into the survey and checking your answer. And next, we will be hearing from Judge Ryan-Calden from the UPC. We will be hearing her presentation on the European DOE. Judge Ryan-Calden, please go ahead, and you have 15 minutes for the presentation.
Okay, thank you so much. And I'll try to cover a few of the main jurisdictions in Europe on the doctrine of equivalence, but mainly I'll try and find some common features of those, which might give you a hint as to where the UPC might go in the future, because we haven't had a case to establish the doctrine of equivalence in the UPC yet. Equivalence is a matter of claim construction. As a general principle of claim construction, the scope of protection of a patent must correspond to its contribution to the state of the art. And this principle is basically laid down in Article 69 of the European Patent Convention, which says that the extent of protection conferred by European patents shall be determined by the claims, but nevertheless the description and drawing shall be used to interpret the claims. Now this was applied quite differently, especially in the continental Europe and in the common law applied in the UK. In the UK, much focus was on the literal wording of the claims, whereas in Germany and other countries such as the Netherlands, there was more focus on the inventive concept, where the claim was rather sort of guiding as to what you would gather from the description that the patentee had meant to cover. So there was a protocol set up to bring these interpretations together. And the protocol says that a balance must be found between a fair protection for the patentee with a reasonable degree of certainty for both parties. So I'm trying to get further than this. Yeah. So now there's a two-step approach to determining the scope of protection. The first step is that you interpret the claim on its wording, but purposively. So you look at, from the standpoint of the person skilled in the art at the priority date, what is the technical function of each element in the context of the overall teaching of the patent, taking into account the description and the drawings. And this exercise entails that you look at what is the essence of the patent, what is the core, what is the inventive concept. There's many ways of saying this. And then the patent is infringed literally when all elements are realized in the attacked embodiment. Now, if the attacked embodiment or method varies from an element specified in the claim, it could still be infringing if it is equivalent. And this doctrine, which is also laid down in the protocol to Article 69, is the same for all type of patents. But it's fair to say that for some
Excuse me, close. More closer.
Oh, sorry. But for some type of patents, it is probably more difficult to satisfy the requirements, such as, for instance, parameter claims that usually have a rather limited scope. Now, I'd like to present a very old a case, which is shown here on the screen, which on the left is a drawing from the patent specification, but I've given you the embodiment in accordance with the patent, which is called the epilady. And at the right side, you find the smooth and silky embodiment, which was by Remington. Now, the patent covered a helical spring, a curved helical spring driven by a motor, and when rotated, it would grip the hairs between its coils and then pluck the hair from the skin. Now, the infringement didn't have the words helical spring. It didn't have that in its embodiment. Instead, it had a rubber rod with slits. But when rotating, it also gripped the hairs and plucked it from the hair. And for this technique with the rubber rods, it also obtained a patent. And this case was run in several European countries, such as the UK and Germany, and also the Netherlands. And then the question is this infringing under the doctrine of equivalence? So while you think about this, I'll go into the theory, and then I'll give you the answers later. So in Germany, Germany has a very long-standing doctrine of equivalence, and they have 3 questions to which the answer has to be yes, and there's one defense. So the first question is about the same effect. Gleiche Wirkung, and that is asking, does this alternative feature solve the problem underlying the invention having the same effect as the feature in the claim? And the second criterion is obviousness. So would the common knowledge of the person skilled in the art would have enabled him to find the alternative at the priority date? So would the person skilled in the art think this alternative would indeed have the same function and effect? And the third question is a bit of a mysterious question, but I think it comes down to the question whether it falls within the same inventive concept of the claim. And the defense is very close to what we heard from Korea and Japan, so the free-to-use technology. So the question is whether the embodiment that is attacked in itself is would be a patentable invention or not in view of the prior art. Because you cannot, of course, cover something that is already within the prior art or is only a non-inventive alternative thereto. And a very similar squeeze non-infringement argument is also known from the UK as a Gillette defense, and that's also recognized in the Netherlands and in practice in France. So basically this argument goes as follows. The attacked embodiment is a non-inventive variant or already belongs to the state of the art at the priority date. So if that's the case, then the claim is interpreted broadly so that it covers the attacked embodiment, but then the patent must be invalid for lack of novelty or inventive step as well. Alternatively, the claim can be interpreted limited in scope and still be valid, but then the attacked embodiment is no longer infringing. So in other words, an equivalent product or process must be inventive in relation to the prior art. In the Netherlands, we have a very similar concept, but these questions are more phrased along the orientation which is set out in the protocol. So the first question is about the technical equivalence. The second looks at whether there is a fair protection for the patentee, which is the case if the inventive concept is sufficiently broad so that the alternative embodiment and the product with it still falls within that same inventive concept. But there also has to be reasonable legal certainty for third parties. So if the person skilled in the art sees good grounds to assume that the patentee actually wanted to limit its scope, then the attacked embodiment cannot be an equivalent. And finally, also, the equivalent element must be new and inventive over the prior art. So we also recognize the Gillette and Formstein defense. Now the UK I'm not going to discuss, and France neither, because I now want to come to the common elements, which is that all of the doctrines in Europe look at the question whether the attacked product with the deviating element from the perspective of the person skilled in the art solves the problem underlying the claim and performing the same function in achieving the solution. And also quite important is that the attacked embodiment must within the scope of the teaching of the claim. So what problem is solved and what does it contribute or add to the prior art? And it must essentially have the same effect as the element mentioned in the claim. Now these are all cumulative requirements, and it doesn't really matter in which order you answer the questions. And I would say it is more an invention approach rather than an element by element analysis. As to the criteria of the obviousness of the variation, so that it must have been obvious to the person skilled in the art that the alternative is an equivalent means. Why is that so? Well, if the person skilled in the art could not at a priority date have found the deviating element for achieving the underlying problem, it takes an inventive step to do so, and then it's not justified that this is covered by the scope of protection of the patent in suit. So in other words, the equivalent must be obvious in relation to the claimed product or process. I think I'm going to skip the question about inventive equivalence. We may come back to this later on, although it's an interesting question. As to new developments, so variations that rely based on developments occurred since the priority date, Richard Mead already referred to it, so-called unforeseen equivalents, they still may be taken into account even though these cannot be obvious at the priority date. And there's two ways of achieving this. The first option, which is used in the UK but also in Germany, it is hypothetically assumed the skilled person was aware of the variant and must be examined whether he would have considered it as an equivalent substitute. Or, and this is the approach in the Netherlands, the obviousness question is answered as at the date of infringement. The third question, the orientation towards the meaning of the claim in Germany, or strict compliance with the language, or the variant must be within the teaching of the patent in the Netherlands and France, leads to similar guidelines. So there is no equivalence if there are indications that embodiments should, outside the literal scope, are not meant to be protected, because, for instance, a selection has been made, or the skilled person would have concluded that strict compliance with the literal meaning is an essential requirement. But there is room for equivalence if the teaching of the patent is clearly broader than the wording of the claim. Furthermore, if several possible embodiments are disclosed in the description, but only one is included in the claim, then we have the dogma of disclosed but not claimed is disclaimed. And if the patentee limits an initially broader patent claim to specific embodiments, and there are indications that the claim was limited to distinguish it from the prior art, there can also not be equivalence. Now, looking at the Epilady case, so in Germany and the UK, the same effect and result, which was obvious to the person skilled in the art, was accepted by the court. But then there was a deviation. In Germany, it was found that the inventive concept behind the Epilady case was broad enough, it being the general concept of using a flexible cylinder with openings that may easily and efficiently pluck hair from the skin. So rubber rods with slits was covered by this general teaching. Whereas in the UK, it was said that the concept of the claim was confined to using a helical spring. But I think it is fair to say that nowadays, I think in the UK, if this case was tried again, it would have found for equivalence. Finally, as to the prosecution history, there is some divergence in Europe as to whether this is done. Of course, in all countries, the patent specification is looked at. In many countries, also in Germany, the published patent application is looked at. So if you compare the patent specification with the original application, you can see what has been amended. And documents from the granting procedure, they can be looked at in the Netherlands and in France. And as a general rule, amendments to distinguish the patent from the prior art may limit the scope of protection. but amendments to overcome formal issues, such as edit matter and clarity, should not affect the scope. In the UK, there's a cautious approach, only if it's truly unclear and the file is unambiguous and may resolve the point. But I'm told that in practice, actually, it never happens that the case turns on looking at the prosecution file and is not in practice looked at. In Germany, it's also not allowed, but their statements in the prosecution file, if brought into the proceedings, can be taken as an indication as to how a person skilled in the art would have interpreted the patent claim at the priority date. So in Germany, basically, they look at the file, then they don't say they look at the file, and then still decide on the basis of it. That's it for Europe. Thank you.
네. 네, 리안 칼든 판사님 감사합니다.
Thank you, Judge Calden. And I received a very quick notification from the staff members. I mean, if you go into the survey, you do have a submit button on the bottom. So if you don't click the submit button, if you don't click the submit button, your answer will not be submitted. So do please click. Do click the submit button. And there is another notice. The panelists, I would like to ask you to speak closer to the mic so that we can offer better sound quality for the audience joining online and in the room. And moving on to part 3, let me ask you a question. So, when assessing equivalence, how do your courts consider prior art? And do they, in practice, differentiate between prior art disclosed in the patent specification and prior art not disclosed in the specification? And when it comes to the prosecution history, under what circumstances does the history influence the determination of influence? And when it comes to the reduced amendments, what kind of decisions are made around that? And if there's no amendment, would there still be covered by the doctrine of prosecution history estoppel? And I would give 3 minutes for each panelist to answer. First, I would start with the Judge Kenji from Japan, please.
Okay. Also, it is not limited to prohibited to parties to file other prior art not described in the specification, but the court tend to take much emphasis on the prior art written in the description. But it's not prohibited to parties to file another prior art when determining the factors, the requirements of the doctrine of equivalence. So that's the answer for the 5th question. And then next, the prosecution showing history. We have a Supreme Court cases in 2017, which is on the material, and the court says that the claim of equivalence should be barred when the patentee has intentionally exclude the sort of scope from the claimed invention, which is should be ascertained when the applicant objectively and visibly indicate his and her intention of omitting patent claim from the patent claim, while recognizing that the above-mentioned composition could substitute for the patent. So Japanese court looks at the prosecution history. So, for example, there is some embodiments or some drawings in the specification, but the applicant failed to claim it up. So they will be barred from the equivalent. So that's the answer.
네, 감사합니다. 마누켄지 판사님.
Thank you for your answer. And next, Judge Richard Mead from the UK, please.
Thank you very much. First of all, any prior art can of course be used to attack the validity of the patent, but I will focus on the importance of the prior art to equivalence and infringement. First of all, in the UK law, prior art that is cited in the patent specification can be used to interpret the claims on the theory that the patentee is unlikely to have intended the claims to mean something that covers the prior art. So that's a question of claim interpretation. Secondly, prior art can limit the doctrine of equivalence according to what's sometimes called the Formstein defense after its development in Germany. And I won't say anything more about that because Judge Calden already covered that in her excellent presentation a few minutes ago. And then thirdly, we have the prosecution history where it's right to say that in UK law it has a limited role. Where it does have potential effect, it doesn't depend on there having been claim amendment. It is in theory possible to have an effect of the prosecution history arising not from an amendment but from a statement from the patentee about what the claims mean or cover separately from amending the claims. But as I've said already, in fact prosecution history has a limited role in the UK. This is an area where there is, as Judge Calden also rightly said, quite a lot of difference in some of the nations of Europe. And I hope that quite possibly with the development of case law from the Court of Appeal of the UPC, we in Europe will be able to move to a more consistent position over time. But that's for the future, and the position for the UK as it stands at the moment is what I said 1 or 2 minutes ago. Thank you.
네, 네, 감사합니다.
Thank you. And moving on to Judge Render Rader from the US, please.
The prior art does not play a direct role in the analysis of infringement, instead falling on the side of validity determinations. We do have a doctrine that says if the doctrine of equivalence expands to a point where it encompasses prior art, then that could not be allowed because you could not have gotten the patent in the first place. You cannot use the doctrine of equivalence to expand what you could not have gotten in the first place. The doctrine of prosecution history estoppel is much more prevalent in the US than in the other jurisdictions. Nearly every patent is amended, and there is a surrender of subject matter. Whenever there is an amendment, you can't apply the doctrine of equivalence to recover any of the surrendered subject matter. And this becomes a prominent part of every doctrine of equivalence case where there have been amendments and they inevitably have some impact on the doctrine of equivalence. Finally, I would note that like Judge Calden said, we have a doctrine that says if you disclose the subject matter in your specification but do not claim it, you have surrendered that to the public domain and cannot recover it using the doctrine of equivalence. Thank you.
네, 감사합니다.
Thank you. Next, Judge Kim from Korea, please. I joined the IP High Court in 2006, and back in the days, after the working hours, we used to drink a lot, unlike we do these days. I mean, the senior judges and I went out for a drink, and we would talk about the equivalence. Should it be the invention as a whole? Should it be the element by element approach? And the judges started talking about the detailed, discussions, and that went on to like 5-6 hours. And I would pass midnight and spend time, talking about this equivalence. And I was sitting in the middle, and I was almost drowsing off all the time. And we have asked a lot of questions about that back in the days, and I do remember some of them. And that is related to the element by element, or the invention as a whole, or the timing of the infringement. I mean, is it the time of the infringement? Is it the time of the priority date filing? And is it only the invention or the prior art invention that is specified or disclosed in the specification, or should we also consider the prior art that was known to the public domain? I mean, when we start talking about this, I mean, we tend to go over the same thing when you're drunk, right? So we tend to have a really long discussions about this. And 8 years in now that I think back, most of the answers to those questions were given by the Supreme Court of Korea, and that's quite, interesting and remarkable. So the discussions that we had actually went into fruition, and it did render some fruits. And I do believe those, drunk discussions were the seeds to the future. Anyhow, I think these are the really fundamental question to the doctrine of equivalence. The adoption of the doctrine of equivalence is about protecting the invention, but it's also about protecting undermining the free, competition of the third parties. So we always need to find the right balance. So sometimes people say that it should only be looking at the wording in the specification, but some others say that the actual value of the patent or the invention will need to be looked at very thoroughly. And to look at that aspect, people tend to write down the patent claims in a really exaggerated manner, and so that the patent's value would be, evaluated in a more exaggerated way. But in the end, the Supreme Court came to the conclusion that the contribution will need to be playing as a really important factor in selecting or determining the scope of protection. So the identity of the problem solving will need to be a really key aspect of the DOE question. So if you look at things from the abstract level, equivalence tests becomes really easy, but then if you look at it in a very narrow way, the equivalence test becomes really hard to penetrate. So considering the prior art to either evaluate the DOE in a wider way or the narrower way is something that we will always need to keep in mind. And the callus remover case, the hypothetical case we covered, it really depends, I think, on the prior inventions and prior art that was available. In the specification, the inventor sounds like this microcutter is the completely new innovative invention, and the patent holder must have exaggerated in that specification. But then, regardless of the shape of the microcutter, the function, and if the problem that is tried to solve is the same, then there is a room for the equivalent infringement to take place. But looking at the hypothetical case, I mean, there are microcutters in the market, and if the key point of the patent or the invention is the shape in and of itself, then the equivalent, infringement will need to be interpreted in a very detailed, narrow way, which is only specific to the shape of the microcutter. So the Supreme Court in Korea has, used this kind of an approach. I mean, for the large new invention, we are using a wider protection area, and for the, narrower inventions, I mean, we are using the narrower protection area. And when it comes to the estoppel, the range or the scope of the estoppel is also differing. I mean, there are strict estoppels and flexible estoppels, but then in Korea we are using the flexible estoppel principle. So the amendments, reduction, or the increase or the expansion would not be directly relating to the scope of the protection, but we will need to consider the different factors holistically. Even if the amendment was made to reduce the claims, I mean, some of it could still survive considering different factors, and we will need to look at not just the prosecution history, but also the post steps like the amendments to apply the Estoppel. Thank you. Thank you, Judge Kim, for your answer. That is actually helping me not to ask an additional question because you passed your time. So let me move on to the next presentation, which will be given by Judge Valerie Thiem from Singapore. Judge Valerie Thiem, please go ahead with your presentation. And you have 10 minutes for your presentation. Thank you.
Thank you. First off, must say thank you for inviting me to this conference. It's such a privilege to be here. So just to explain the Singapore theory, and perhaps maybe just to explain a little bit about Singapore as well, as not many of you might be familiar. In Singapore, the highest court would be the Court of Appeal. It can sit as 3 or as 5, depending on whether they have points of law that they want to deal with. And then below the Court of Appeal, there's the High Court. The High Court has the Appellate Division as well as the General Division, which is where I sit as part of a specialized IP list. And we also hear appeals from the state courts and from IP tribunals like the Intellectual Property Office of Singapore. So to explain, in Singapore we do not yet have the DOE, and what we use, but first before we do that, we have to explain it in the context of the fact that we have a purposive claim construction approach. So it's purposive in that we ask what the skilled addressee would have understood the patentee to have used the language of the claim to mean. Now, so what we have, we followed the old UK approach, pre-activist, and it really talks about the true construction of the claim itself. And the description and other parts of the patent specification form the context and assist in the construction of the claims. So we approach it from the viewpoint of the notional skilled person, taken to be a workman or a technician who is aware of everything encompassed in the state of the art and who has the skill to make routine workshop developments, but not to exercise inventiveness. Now, so the 3 questions would be the improper questions, which Judge Mead has dealt with actually. Does the variant have the material effect upon the invention? If yes, then the variant is outside the claim. If no, then would this have been obvious to the notional skilled person at the time of the patent filing? If yes, then the 3rd question applies. Would the reader skilled in the art nevertheless have intended that that the claim be restricted to the 4 corners of the claim? So those are the 3 questions, and basically the court gives primacy to the language adopted by the person who drafted the claim. It's really a claim construction approach. And so one example is this case where the patent really talked about resin molding, and the patent itself referred to the unit as 5 and then other units as 5A, 5B, 5C. When the defendant was sued, basically the defendant said that, oh, this claim is really about 3 other units, and in total there must be 4 units. But in approaching the construction, the Court of Appeal then held that it's not a literal construction, it's purposive. And basically, when they looked at the expert evidence, they concluded that the 5A, 5B, 5C, that was not meant to be exhaustive, and really it was just an illustrative approach, and the patent was infringed. Now, the Court of Appeal in Singapore has considered the doctrine of equivalence twice. The first time was obliquely and and it was about the US doctrine of equivalence, and when that was rejected then, it wasn't very surprising because the US approach is really a literal construction, whereas in Singapore we adopt a purposive construction, and there was thinking that maybe the purposive approach was really enough. Now then, after that, the UK changed its mind, as Judge Mead has described, and in Lee Touching, the Singapore Court of Appeal considered whether we should go the same way. Now, so the difference in activists is really in this limb B, that even if it's outside the claim, does the variant nevertheless infringe because it varies in a way that's immaterial? So in Lee Touching, basically the Court of Appeal talked about the different legislative schemes, and really its answer was limited to our Patents Act, and it said that the Patents Act really talked about how claims should be determined at the time the claim was filed and as determined by the four corners of the claim. Now, the Court of Appeal also had some other reasons. Basically, they felt that it is fair for a patentee to be bound by the language in which he has drafted his own claim. And they also thought that if you apply the purposive approach, it caters to most of the limitations of language. And basically, they felt that you need to strike a balance between the fair protection to the patentee and secondly, the need to provide a reasonable degree of certainty to third parties. And they were concerned that the doctrine would cause undue uncertainty, and they felt that the purposive approach gives rise to greater certainty because whatever it is, you fall back on the claim, and the DOE brings an element of ex post facto analysis. So actually the Court of Appeal really left it to Parliament, whether Parliament wanted to change the Patents Act, but then the question still remains whether certainty and fairness would be enough or not. So there is a difference in the approach, right? Because if you see from the activist case itself, it could well be that it is within the four corners. It is not, this new patent may not be on the four corners of the claim, but it could be something that would be considered non-inventive. Because in activists, the primary claim was for the use of a particular chemical, and the respondents' products replaced that chemical as the active ingredient with other compounds that were similar. So it's an issue for discussion even in Singapore whether the Patents Act should be amended. So thank you.
Thank you, Judge Valerie Thian. So the UK has gone through some changes with regard to the DOE, and watching how UK moves, different countries are looking at it cautiously to make research, and Singapore is one of the. So it is such a meaningful occasion that we can watch those two countries in one setting. And let me move on to the next part, which is part 4, and let me ask you this question. So we have the numerical limitation inventions and parameter inventions, and there you have the numerical numbers. And how does your jurisdiction determine whether an accused product that exceeds the numerical range specified in the claims constitute infringement under the doctrine of equivalence? So if the numerical range is exceeded, how do you judge based on the doctrine of equivalence? And if you have any cases with regard to that, please share those examples. And if you have any additional thought that you would like to share with regard to the DOE, please share them. I will give 2 minutes each to the panelists, and we will start from Judge Kenji from Japan.
All right, 2 minutes, okay. We don't use difficult approach depending on the type of invention. But generally, about numerically limited inventions, as I described here, courts are reluctant to apply DOE in such sort of invention because there is the mindset that such invention are patented by its parameter itself. So the scope of them is very clear-cut. So there is very interesting case in Osaka this year. So the UV absorbers molecular weight was 699.99, while the patent composition was over 700. And it's not direct infringement, and it's not equivalent. This case is appealed to the IP High Court, and the judgment will be rendered maybe soon. So as this example shows, courts are not reluctant to apply doctrine of equivalence so frequently. I don't know why, but maybe it's. I'd like to hear about what is happening in the other jurisdictions. Thank you.
네, 네 감사합니다.
Thank you.
영국의 리차드 미드 판사님.
And Judge Richard Mead from UK.
Thank you very much. In principle, the activist questions can apply to all kinds of claims, and in fact, as far as I know, they have been applied to all kinds of claims. But in a limitation to that statement, the third question in activists allows the type of the claim to be considered in deciding whether the patentee deliberately intended a narrow scope, and with numerical ranges in particular, and especially where the range constitutes the inventive concept, as Judge Amano said, then I think it is likely that those kinds of claims will not be very subject to the doctrine of equivalence. Thank you.
네, 감사합니다.
Thank you. Now, Mr. Rader from the U.S., please.
Yes, the Warner-Jenkinson opinion actually did deal with a numerical range, and the court permitted the equivalence analysis on that, but narrowed it so considerably using both prosecution history estoppel that it makes it very difficult to see how equivalence could apply if there's been any amendment to the range, and further, if you vary from that numerical range, it becomes very clear that you have exceeded the claim scope of the invention, and it becomes very difficult to say that that's the same way. You've actually done something other than the same way by exceeding the claim limitations.
네, 네 감사합니다.
Thank you.
김기수 판사님, 부탁합니다.
Judge Kim, please.
감사합니다. 일반론으로 말하면
Well, let me touch upon the general concept. So numerical limitation invention does not apply with the DOE. I mean, we cannot say that. Whether it is the numerical limitation invention or the parameter invention, I mean, they would need to go through the same equivalence tests as other cases. But if the numerical limits do have the technical meaning, then when the range is exceeded, then there is a higher room for it to be considered a different invention. That is why it is very likely that the equivalence test would not be met. But then I do have a case that I quoted in the booklet. So this is related to a pharmaceutical item. So even in the strong acid condition in the intestine, it will be still absorbed, and even at the bottom of the intestine, it will still be absorbed. And the patent was designed in a way that the absorption would be happening in both ways. So the top part of the intestine and the bottom part of the intestine, they check the pH level of the acidity, and the coating of the medicine was double coated so that it would be once melted at the top of the intestine and would be melted once again at the bottom of the intestine. So it had the tablet that would be melting in 2 different steps, and that was patented. And this pH level was defined based on the numbers, but the infringing product was exceeding the parameters, but then it had the same sort of a approach, the double coating to have the double melting in two different parts of the intestine. So by understanding it from many different factors, in that particular case, the key point was not the numerical numbers, but was the method, the double coating that is dependent on the pH level on different parts of the intestine, and the equivalent infringement was acknowledged in that case. Thank you. Thank you. We have heard from the panelists on the prepared questions, and I think I gave a really big question and gave them only 2 minutes or 4 minutes, and I feel very sorry for doing so, and I want the audience to give them a big round of applause for doing that in such a short time frame. I'm sure that you have submitted your survey result now. I believe that you did. So I would like to ask the panelists on their esteemed thoughts on this hypothetical case. So you do, have the hypothetical case in front of you, and please share your, simple and off-the-cuff answers. Maybe we will start from Judge Ryan Calden from the UPC.
Sure, fine. So in this particular case, there is quite some emphasis on the specific gourd shape. Now, it's very difficult to say what the inventive concept of this patent is, because we're lacking any background as to the patent specification. We also don't know what the prior art is, so we don't know what the contribution to the prior art is. And what the actual problem is that is solved if you look at it from that perspective. But looking at the facts that are given to us, I would say there is so much emphasis on the actual shape, and also the shape from the facts that we are given seems to be quite essential to achieve the effect. That I would say in this case it would probably not be covered, because the inventive concept is limited to the specific shape that is claimed. Do you want me to also reflect on the second question?
네.
Okay.
Yes, please go ahead.
Okay, so then the second question is if the patented invention involved the microcutters and the defendant's product used a gourd shape, could that constitute an equivalent infringement? Well, that's a very interesting question. If you look at the facts of the first scenario, and you look at what does the shape do, and it did merit an invention, then I would say at first glance, possibly not, because if you take it from that perspective, it would not be an obvious alternative to the skilled person that this good shape would achieve the same result. However, I should note that it's not impossible for an equivalent embodiment to be having a patent itself, but that can only apply if the patent relates to another problem than the problem that is solved by the patent that is invoked. So looking at it again, and the starting point is the circular microcutters, and you say, well, the inventive concept is sufficiently broad to also cover embodiments with other shapes but doing the same thing, then it could be said that the infringing product is using the same concept, the same core, the same invention, and then provided that the gourd shape would be an obvious variant to the circular form, it could be held to be an equivalent. And then, for instance, if the gourd shape solves another problem, I haven't thought of any, but if it solves another problem, which is inventive, then it could merit an invention for that aspect, and then it would become a dependent patent.
네, thank you. 감사합니다.
Thank you.
네, 이어서 싱가포르
And next, I would like to hear from Judge Valerie Thin from Singapore.
Thank you. In the handout that you gave us, there was an explanation to the specification. And in that explanation, basically, it says that due to the two protruding points, the cutting begins at two locations, allowing for a broader area of callus removal with a single motion. So the side blades between the 2 points face each other, enabling the smooth cutting callus to gather between the two side blades. So it seemed to me that the main point of this was to have two blades facing each other. So although on first glance, it would, on a literal, if you take a literal approach, then we would say the circular product is not the same as the gourd product. But if we look at this in a very purposive way, it could be possible. And it's not so clear from the details of the circular product. But if the circular product had these two blades that face each other and can be used in the same way, then I would think that it would infringe on the purposive approach, because it would not be a material variation.
네, 감사합니다.
Thank you.
일본의 아마노 켄지 판사.
Now I will ask Judge Kenji from Japan.
Okay. I think it depends on what is written in the specification, but on the premise that the prior art is the razor blade, and this sort of micro cutter plate hasn't been existed before the filing of this patent. It might be that this sort of micro cutter plates is the inventive concept of this patent, so it should meet the requirement number one, and the dependent product enjoys its effect. So I think it would meet the requirement number two and maybe three. I think it depends on what is written in the description, whether the dependent product meet requirement number 4 and 5. If there are embodiments of the circular shape, but the patentee failed to claim it up or omitted this sort of claim during the prosecution history, the circumstances might bar the enforcement of the patent. Okay, and question number 2, and in that case, the issue is whether it is easy for the skilled person to modify the shape of blade cutter from circular to gauge shape. So it's a problem of requirement number 4. So whether it is obvious at the time of infringement to modify the shape of micro cutter. So I think at the first glance, I think it's obvious, but there is some sort of inventive step by modifying the shape of the blade. It have some sort of technical advance. So it might be meet the requirement 4. So when that circumstances, maybe the doctrine of equivalence would apply to that case. Thank you.
Yes, thank you. 감사합니다.
Thank you. And Richard Mead from UK, please.
Thank you very much. Can I first of all say what an excellent hypothetical question I think this is. It's extremely difficult to put together questions like this to raise all these issues in just a couple of pages, and I think it's very impressive. From the point of view of answering the specific questions, even though the United Kingdom is not part of the UPC, I fully and entirely agree with Judge Calden's excellent answer and have nothing to add.
네, 그렇군요. 감사합니다.
I see. Thank you. Judge Rader, please.
Yes, I would also see that
마이크
this claim focuses on the gourd shape, the function, result, the way is tied to that gourd shape, and that would probably preclude the doctrine of equivalence. I would add one additional concept which we haven't discussed, which is very close to everything we've talked about, and that's foreseeability. The creator of the infringing product here made a slight variation. That should have been fully foreseeable to the patent draftsman. They should have claimed their invention in terms that would have also encompassed a shape circular, but not with the emphasis on the gourd features. We should not correct claim drafting using the doctrine of equivalence. So when it's foreseeable that they should have claimed it properly in the first place, we shouldn't correct that using the doctrine of equivalence to allow them to get scope they should have claimed in the first place.
네. 네. 네, 감사합니다.
Thank you. And Judge Kim? Thank you. This example is quite fun to look at, and I really hope to use two different types of callus removers myself and use it so that I can see the effect of the two different types to be able to give a clear answer. But anyhow, I mean, we do have the gourd-shaped patent, and we are talking about whether it is equivalent with the circular-shaped cutter. And I mean, as the other judges have said, I mean, we do not have enough information to be able to give a clear answer. So in a specific real case, I mean, it may render a different result, and maybe different people may have different opinions. But then based on my personal point of view, we will need to consider the prior art. The first prior art to the microcutter is the abrasive stone, and that's too difficult, it said. And the razor blade is very convenient, but when you do a clumsy work, then it will, cause injury. So to address these two concerns, I mean, the microcutter has been invented. I mean, that is what is explained here. If that is all it explains, and if you don't too specifically focus on the gourd shape, then it could have covered a wider scope, but it wasn't the case. I mean, you actually specifically focused, the patent holder specifically focused on the shape of the microcutter and even talked about the specific effect that comes from the specific shape of the microcutter. So the gourd shape of two protruding sides and the concave middle, I believe, is a part that the patent holder wanted to highlight. So I believe that the defendant product doesn't have such elements. So it would be probably negated even at the first requirement. And the effect may not be the same either. In the defendant's product, I mean, it doesn't have the double, sided protruding edges, and that may not result in the additional cutting. But when it comes to the circular shape versus the gourd shape, I mean, there can be some differences between the two. In the specification, the circular shape is not just about the direction of the blade. I mean, it is about, having the same effect across the board regardless of the direction of the blade. So that actually could be, covered that kind of effect can be effectively covered by the gourd shape. So I believe that the first requirement would be passed, but then, and the second requirement would be also passed. But then the third requirement, which is the obviousness, is something that would be a hurdle. So the gourd shape and the circular shape, in my opinion, the effect will need to be really compared. And I did look at the video of the differences of the effect of the two different types of the shapes, but then it really would be decided differently based on the evidence that is presented to the court. So let me summarize. In the first case, I mean, it would be easy to be for the DOE to be negated, but then in the second case, it is likely that it will be more accepted. Thank you, Judge Kim. And listening to your answer, I am once again, impressed by this hypothetical case, and I can clearly tell who prepared this because you gave me such an impressive answer. So let me see the result from the audience. A lot of the audience members gave us a reply. Okay, we have 48% that it constitutes infringement and 53% that it does not constitute infringement. Okay, the second question, yes, it is an infringement, 51%. No, it is not an infringement, 49%. Well, I was expecting more tilted result, but there it was a comment that this was not a technology that was available in the prior art. So I believe that was the reason why we had a really balanced poll result. And thank you so much for your participation in the survey. Any special comments from the panelists? Judge Calden, please go ahead.
I would have a comment to Judge Rader's comment, not so much to the case, but to the foreseeability requirement. If I understand correctly, the idea about this foreseeability is that if there is an alternative that is an obvious alternative to the claimed element at the priority date, then the patentee should not be able to claim it because he should have thought of it from the outset. I don't think this is as such the way the equivalence doctrine is looked at in Europe. There is the requirement that the alternative embodiment must have been must have been able to be found, because otherwise the alternative embodiment would be inventive. But it's not that if it's obvious, equivalence would be excluded. Basically, it would be sort of basically the death to the doctrine of equivalence, because then either way it doesn't work. So what is excluded normally is if the description or other indications in some countries are that the patentee actually considered the alternative that would be an obvious equivalent, but didn't claim it. And that can be either by already having it in the description and not claiming it, so then it is disclosed but not claimed, and therefore disclaimed. Or there is a description, there's a whole explanation as to why this particular embodiment, for whatever reasons, is more superior to other alternatives, and then there is a deliberate choice, so that the person skilled in the art considers, well, the patentee actually wanted this particular embodiment to be claimed and no alternatives that do not have these required specifications that are particularly useful for this invention. So I think that there is a slight variation in your approach as to the one in Europe.
네, 리안 칼든 판사님.
Thank you, Judge Galden, for your insight. I'd like to thank the audience members on the floor for their presence. And if you have any questions, we would love to hear from you too. And you may have something to say about the hypothetical case and your judgment about the hypothetical case. So if you want to share your thoughts, please raise your hand. Okay. Well, but I see no hands in the air, and it's about time. So I think we can close the second session. So Honorable Judge Amano Kenzie, Judge Keldon, Judge Mead, Judge Rader, and Judge Tien, and Judge Kim, thank you so much for your time, and I think I will have such fond memories of this session. Please give them a big round of applause, everyone. And I am very thankful for all your heated interest in the session. Hope you enjoy the rest of the evening. Thank you. This concludes the second session, and I would like to thank the moderator and the panelists for their active discussions.
잠시 후에 휴식 시간을 가진 후에
We will have a short break.
저희가 지금 원래는 4시부터
We are slightly behind schedule. We were supposed to start the session 3 from 4 p.m., but we are at 4 already, so we will have 10-minute break, and we will start the third session at 4:10 p.m. And we will take a group photo of the panelists and moderator of the second session.
괜찮아질 겁니다.
패널들은 벌써 다 앉으셨는데. 잠시 후 3세션을 시작하겠습니다. 여러분께서는 모두 입장하셔서 자리에 착석해 주시기 바랍니다. Session 3 will begin shortly. Please enter the conference room and take your seats. Thank you. 네, 저희 3세션 시작하겠습니다. 지금 벌써 패널들은 착석을 하셔가지고요.
We will start with the third session. Already the panelists have taken their seats, so I'd like to ask the audience to follow suit and return to the conference venue. Thank you.
예, 그러면은
We will now start.
오늘의 마지막 세션이
Last session of today, session 3.
3세션에서는
And here we will look into the emerging issues on pharma and biotech invention, moderated by Honorable High Court Judge Song Wood-woo of the IP High Court of Korea. Please welcome our moderator with a round of applause.
네, 안녕하십니까.
Good afternoon. I'm Judge Woo Sung-yeop of IP High Court of Korea, and I'll be your moderator for
생명공학 관련 발명은 우리 시대 과학적,
technology, which will be the theme of this session, are at the core of scientific and medical progress of
치료법의 발전뿐 아니라 삶의
advances in disease diagnosis and treatment, as well as improving our quality of life. These inventions also play an important role in patent disputes and are directly related to competitiveness in the global market.
각국의 저명한 판사님들과 함께 중요한 주제에 대해
To discuss this important topic, and I look forward to very fruitful discussion. Now, before we get started, I will introduce the panelists of session 3 in alphabetic order of their family name. Please welcome them with round applause. First, we have Judge Kenji Amado on my left from Japan. Then we also have presiding judge Lei Fu of the Supreme People's Court of PRC. Then we have Judge Maximilian Hadeke, UPC, from the UPC, Paris Central Division. Also, we have Circuit Judge Kent Jordan from the U.S. Court of Appeals for the Third Circuit. And we have returning panelists from session 2, Judge Richard Mead of the High Court of England and Wales. Lastly, we have Judge Lee Ji-young, High Court Judge of the IP High Court of Korea. So I'll just call you as judges during this panel discussion, and they have already given us experts and detailed written response to the topics, which are included in the reference book. And due to time constraint, we may only be able to present or respond to highlights. So we ask for your understanding in advance. And if you want to, read all the details, please refer to the reference book or the booklet. This session is organized into two parts. In the first part, each panelist will give a 10-minute presentation invention using the prepared PPT on the latest issues related to the topics that we are going to handle in this session. Then in the part 2, we'll hear answers to the questions sent from the panelists by country and discuss the legal system and practices in their respective countries. So in this slide, you can see the field of medicine biotechnology inventions is globally connected, and disputes over a single patent invention can arise in many countries. So it is very necessary and meaningful to review and discuss comparative legal cases in different countries. Now, we will listen to the presentations, and again, in the alphabetic order of the family names of the panelists, and I would like to ask everyone to comply with the 10 minutes constraints of each presentation. And we'll start with Japan. Judge Kenji Amano is going to talk about the pharma and biotech inventions on about Japan. So please, you have the floor.
Okay. Thank you. Talking about pharmaceutical invention is very difficult task for me, but I will do my best. Today, I will introduce 2 Japanese patent cases. First one is regard to secondary use inventions, and the second case about polymorphs. Okay. When we discuss secondary use invention, one of the most controversial issues is whether or not disclosure of such use in the specification is enough. Like other nations and areas, Japanese Patent Act has some requirement for the description of the specification. One of those requirements is called support requirement. Basically, it requires the applicant to state the claimed invention into the detailed explanation part of the specification. The basic idea is that substantial part of the claimed invention should have enough basis or support in this specification. Okay. Of course, this explanation just technically copying the claim and passing to one of the leading IP High Court case in 2005 describing here held that whether or not the claimed invention is stated should be determined by looking both claims and descriptions and considering whether the skilled person in the art could understand that the claimed invention would solve the problem. That's the general rule. Okay, so let's step forward to today's first case. This is one of the famous global patent disputes by patent holder Warner Lambert about the second use invention of pregabalin or Lyrica. One of the corresponding patents is written below, EP 09346061. This is a very famous case, and maybe Justice Mead will explain later. But the gist of the case is the pregabalin is existing known compound, and the claimed invention are 1. Use of pregabalin for treating all types of pain, and 2. Use of pregabalin for treating neuropathic pain. However, as UK Supreme Court holds, there was not enough scientific reason in this specification with regard to neuropathic pain. On these circumstances, IP Court held that the claimed invention did not satisfy the support requirement. because lack of description hampers the understanding of the skilled person in the art, how the inventors would solve the problem, in this case to treat all type of pain. Some of IP High Court decision held that this is the issue of enablement. I think both are okay, since support requirement and enablement requirement is asking similar thing to the applicant. Anyway, this decision held that the claim invention is not supported by description. Okay, move on to the next case. Okay, polymorphos. I have to admit that the past several years, IP High Court of Japan had been relatively strict for inventive step of polymorph invention. The arguments are follows, the reasons are follows. Especially for pharmaceutical compounds, crystalline forms are superior than amorphous in several aspects. And for the skilled person, polymorphism screening of known compounds are some kind of routine, and they would have a clear expectation to get improved product by this routine. There is a motivation for skilled person to routinely try and error to get improved polymorphs. So it has been hard to get patent for polymorphs inventions. However, there are some exceptions. One of those is this case. So in this case, claimed invention was the crystal forms of strophyrin, which have I can read my, particular particle size and on crystallinity. However, other crystal form of this compound was known as prior art. For that case, court held that the claimed invention has an inventive step. Why? Because the problem to be solved by the invention was hit the balance of solubility and stability, which is not realized in prior art. And there was a common knowledge that when skilled person raised crystallinity to improve stability, it hampers solubility. There was a trade-off. So there was technical obstacle to get the claimed form of this compound. And the data in the description showed an unexpected advanced technical effect. Those were reasons by the court. So to sum up, in order to get polyforms invention patented, applicants have to show both difficulty to get that form and its technical effect. I think this approach is very similar to other nations and areas, including Korea. Finally, this is my sort of advertisement. This is a nice time to introduce myself. I am a triathlete, and one of my dreams is to participate in Ironman race in every single continent except Antarctic. So we will meet again in anywhere in the world at Ironman race. Thank you for your attention. Okay.
네, 아마노 판사님 감사드립니다.
Well, thank you so much. Now, you present two very interesting case, Warner Lambert, a case I believe Judge Mead would also talk about this. And as you have heard, in the UK, it failed to meet the sufficiency requirement, but in Japan, it did not meet the supporting claims. So maybe we can compare that. And in terms of crystalline, inventive step was recognized, and I believe in Korea, We will also talk about inventive steps, so we could also compare that against the Korean case. Thank you very much. Now we will move to China.
최근 중국 특허법의 개정에 따라 도입된 의약품 특허 분쟁의 조기 해결 메커니즘.
So, Lei Fu from China will be talking about China's pharmaceutical patent linkage litigation practice. Ms. Fu, please go ahead.
Okay, thank you. Good day to everyone. I'm honored to be invited to this conference. Today, I will focus on China's pharmaceutical patent linkage litigation practice. My presentation will cover 4 main points: the importance of the system, the pertinent laws and judicial interpretations, an overview of its judicial practice, and finally, some typical cases in China. The field of pharmaceuticals and biotech is one of the areas with the highest technological content and most active investment. It's a key sector promoting public health and safety, and an essential area that China's patent judicial practice have been emphasizing over the past 2 years. To promote resolution of pharmaceutical patent disputes, China has recently established a system called Pharmaceutical Patent Linkage System. Moving on to its legal sources, the Pharmaceutical Patent Linkage System was introduced to the China's patent law through its 4th amendment in 2020, specifically in Article 76. This system sets up an early dispute resolution mechanism for pharmaceutical patent disputes. Under this framework, the originator pharmaceutical company is required to accurately register its pharmaceutical patent information. While the generic drug company must submit one of the 4 kinds of declaration. In particular, for the 4 kinds of declaration, if the patent holder or originator drug or a stakeholder has objection, they can either file a lawsuit in court or request administrative adjudication from the Patent Administrative Department. This process then triggers pharmaceutical patent linkage litigation. To ensure proper adjudication of these civil cases, in 2021, the Supreme People's Court issued a judicial interpretation. This interpretation provides clear guidance on key issues, such as the competent court, the course of action, and the principle of res judicata of the cases. These measures are designed to facilitate the substantive resolution of early disputes regarding pharmaceutical patents. Now, let's shift our focus to its real-world application. Since November 8, 2021, the SPC has accepted 37 civil second instance cases related to pharmaceutical patent linkage and has concluded 31 of them. For a few key cases that exemplify its implementation, Firstly, I would like to highlight the case, the Chugai company with Wenzhou Haihe company case. In this case, the plaintiff held a patent for an originator drug, while the defendant applied for a generic drug that made a full-time declaration, claiming that the generic drug did not fall within the scope of the originator drug's patent protection. In response, the plaintiff filed a lawsuit with Beijing IP Court, seeking a ruling that the defendant's generic drug fell within the scope of the patent in question. The Beijing IP Court found that before the defendant submitted the full-time declaration, the plaintiff had amended the Claim 1 during the administrative procedure. Initially, Claim 1 does not specify the selection of antioxidants, but after the amendment, the plaintiff abandoned 3 of the antioxidants, retaining only 1. Notably, the antioxidants used in the defendant's generic drug happened to be one of those 3 that the plaintiff had given up. The Beijing IP Court held that, firstly, the antioxidant used by the defendant differed from the specified in the plaintiff's amended Claim 1. Secondly, regarding the doctrine of equivalence, since the antioxidant used by the defendant was mentioned only in the patent's specification and not in the claims, it had been dedicated according to the doctrine of dedication. This doctrine served as a limitation on the doctrine of equivalence, meaning one cannot evolve the doctrine of equivalence to reintroduce a deleted technical scheme back into the scope of protection. Consequently, the court determined that there was no equivalent infringement. Ultimately, the Beijing IP Court concluded that the generic drug did not fall within the scope of the plaintiff patent. The plaintiff appealed to the SPC, which ruled that, based on the principle of estoppel, the plaintiff had abandoned the other 3 antioxidants during the prior patent invalidation procedure and could not now claim equivalence in this case. Therefore, the SPC upheld the first instance judgment. Additionally, the court criticized the defendant for failing to meet the obligation of declaration and notification related to generic drugs. As the time is running short, so I regret that I cannot continue with more typical cases. To conclude, Chinese courts highly emphasize balancing the interest of originator and generic drugs, focusing on the substantive resolution of conflicts within the pharmaceutical patent linkage system, and drawing from international experience in pharmaceutical patent protection. We look forward to sharing insights, fostering collaboration, and working together with countries worldwide to enhance and advance the pharmaceutical patent linkage system. Thank you all.
Well, thank you very much. We heard about the China latest patent dispute resolution system, talked about the law as well as actual cases. Thank you so much. We will now move to Europe, and UPC Judge Hedike is going to talk about first case issuance for preliminary junction.
UPC 판결 사례와 진보성
and
판단의
also
새로운 기준과
new
절차를
standards and
제시한 것으로
procedure
보이는 UPC
that's related to
판결 사례들에
inventive
관해서 발표해 주실
step
예정입니다.
and any UPC case related to that.
판사님
So
부탁드리겠습니다.
please go ahead.
Thank you very much, and let me start with a few personal remarks. First of all, yesterday I visited Seoul, and I was very impressed about how well organized, how smooth, how friendly, how efficient everything is. I'm just used to be in Berlin, so things are quite different here. And so is the conference. It's well organized, it's high level, it's friendly, it's professional. I really enjoy being here, and thank you very much for having me here. Secondly, I learned that this conference celebrates a birthday, a 10th birthday. I personally can also celebrate a birthday because yesterday the first two judgments of our panel of the Paris Central Division were issued about vaping devices. So we issued after 15 months of the court our first judgment. It feels really good to have the first judgment out there. Thirdly, this court is around for 15 months now. Some people call it a baby. I don't know if that's true because you would not trust your pharmaceutical patents to a baby. But I think this baby can start to work now. It grows, it gets smarter, and we hope it's a prodigious child. Mozart wrote his first major works with 5 years. We started with the first year, so we are very optimistic, even though we cannot compare our work with eternal music. It's always good to have a role model. Then fourth, I want to apologize for submitting nearly 30 slides, which is far too much for a 10-minute or 8-minute presentation now. It's indulgence if it's even worse when one considers the fact that the UPC has until now only decided 2, or you can say 3 major cases in the field of pharmaceutical patents. So please excuse me when I sum up something and skip some slides. Needless to say that I express my own personal opinion and do not speak for the court. As already said by Judge Carlton today, there were a certain reluctancy to trust pharmaceutical patents, the crown jewels of the pharmaceutical industry, to the UPC. There were some questions. Just find this. Who will be the judges? Will the UPC be patent friendly, whatever that means? And then, of course, what standards will they apply? Will they apply the EPO principles of patentability, or will they make up something different? In the remaining time of my presentation, only 7 minutes, I will introduce 2 major cases which UPC issued in this field of pharmaceutical patents. I will try to at least hint an answer to these questions. First case I want to talk about is nanostrings against Tae-ak Genomics. It concerns compositions and methods for analyte detection on a cellular tissue sample. Sounds complicated, it's complicated. The Court of Appeal overturned the decision of the Munich Local Division and set aside the PI. The Court of Appeal has clarified that a sufficient degree of certainty requires that the court considers it at least more likely than not that the applicant is entitled to initiate proceedings and that the patent is infringed. A sufficient degree of certainty is lacking if the court considers it on a balance of probabilities to be more likely than not the patent is not valid. In the case, the Court of Appeal considered the standard not to be satisfied. Without diving deeply into the facts of this case, it suffices to say that the court found that the skilled person would have considered certain documents which are close to the invention, and the skilled person would also have considered to transfer certain analyzing techniques. Therefore, the Court of Appeal decided that it's more likely than not that the patent at issue will be proved to be invalid in proceedings on the merits due to a lack of inventiveness. Hence, there was no sufficient basis for the issuance of a preliminary injunction. I will now talk about the second case, and I did not say anything yet about the standards applied by the court to identify an inventive step. I will discuss this in connection with the second case I want to introduce. This case concerns a revocation action before the Munich Central Division between Sanofi and Amgen. The patent held by Amgen concerns an active ingredient called evocumab, a cholesterol-lowering drug. Besides claim interpretation, the Central Division had to deal with the requirements of an inventive step. Leaning on the appeal decision in the previously described nanostring case, the Central Division identified some basic rules for determining the inventive step. First, whether there is an inventive step is to be assessed in each individual case and requires legal evaluation of all relevant facts and circumstances. Secondly, an objective approach must be applied. Subjective ideas of the applicant are irrelevant. It's also irrelevant whether the invention is the result of systematic work. It only matters what the claimed invention actually contributes to the prior art. And the inventive step is to be assessed from the point of view of a skilled person on the basis of the state of the art as a whole, including a skilled person's common general knowledge. So that means that the Munich Consent Division identified the following test. First, identify a realistic starting point in the state of the art. Then compare the claimed subject matter and prior art to determine whether it would be obvious for the skilled person to arrive at the claimed solution. What is most important, I think, is that by applying this test, the Munich Central Division did not strictly follow the EPO's problem solution approach. Instead of identifying the closest prior art, it said that a realistic starting point was required. A starting point will be considered realistic if its teaching would have been of interest to a skilled person who was seeking to develop a similar product to the disclosed in the prior art and therefore had a similar underlying problem as a claimed invention. There has to be such justification as to why the skilled person would consider a particular part of the state of the art as a realistic starting point. There's not one exclusive starting point to be identified, but there can be several starting points. What matters is that the CD concluded that using the starting point, the person skilled in the art would pursue the route of developing antibodies, thereby arriving at antibodies as defined in the claims without inventive skill. And the CD also considered it to be relevant that the priority date of a significant commercial interest in the target for the treatment of hypercholesterolemia. The take-home point of this judgment, hold on, I'll skip all the details here. The take-home point is that two steps are required for the examination of the inventive step. First, find a realistic starting point. Secondly, the claimed subject matter and the prior art are compared to determine whether it would be obvious to the skilled person to, starting from a realistic starting point, arrive at the claimed solution. Let me add that after I finalized my preparation for this conference, another case was decided by the Munich Central Division, which concerned a patent closely related to the first nanostring case. And the Central Division, which is no surprise, revoked the patent due to the lack of inventiveness. Let me finish with trying to give you some answers to the questions I started off with. First question was, who will be the judges? The judges of the UPC are, with very few exceptions, judges of the national courts. The judges have been elected with a view to their competency and not by applying political considerations. Secondly, will the UPC be patent friendly? My answer is, of course, we are no anti-patent activists. But apart from this, we're neither patent-friendly nor patent-unfriendly. We just apply the law and, when necessary, contribute to the further development of the law by taking into account all interests. Third question, will they follow the EPO principles on patentability? It's too early to say that. I cannot answer this question, at least for now. It can be said that the UPC has not clearly announced that it follows the EPO law. The UPC should start, again with what I said in the beginning, starts to walk, and we're very optimistic that it gains confidence by the patentees. Also in the field of pharmaceutical patents, we do our best, and the toddler speaks German and English. Thank you very much for your kind attention.
예, 감사드립니다.
Thank you so much.
그러면 이어서
Now we'll move our, we'll go to the US.
PPT를 준비해 주셨습니다.
So he has come with the presentation material. So he's going to look at the Supreme Court's Amgen versus Sanofi case, where they look into the enabling requirement and also about the obviousness, and if time allows, latest legislative trend of the US Congress. Please.
I want to second everything that Judge Heideke has said about the conference. It's beautifully organized, so I'm just so grateful, just really thankful to be part of this, and honored to be here. It's election day back in the United States, so I'm grateful to be anywhere except the United States. It's a little crazy back there right now. I'll speak about the U.S. perspective, as was just mentioned, on some issues, but let me just say that in American football, when a quarterback sees something developing on the field, he'll do sometimes what's called calling an audible, which means changing the play. So I'm calling an audible, and given the hour and the amount of time I have, I thought I probably won't discuss the issue of obviousness type double patenting. In the spirit of Judge Kim's confession to conversations over the doctrine of equivalence with lots of alcohol, I'm afraid I might drive you all to drink if I started talking about obviousness type double patenting. So instead I'm going to focus on the Amgen versus Sanofi case, and then I will talk a little bit about three pieces of legislation that are pending in this Congress, and which probably are not going to get past this Congress, but I think have some fair prospect in the Congress to come. So, turning to Amgen, I begin by echoing something that Justice Scalia of the U.S. Supreme Court said when he concurred in a biotech patent case, and basically stated, "I'm concurring because, frankly, I don't understand the science." He had enough self-awareness to step up and say, this is very hard stuff. And I'm not like my great colleague and friend here on the dais, Judge Yi, who's got a doctorate in pharmaceutical sciences. I'm a generalist judge who just loves patent cases, and when it comes to biopharma cases, I feel like I really have to get my nose to the grindstone to understand the science. Amgen is versus Sanofi involved biologics, and that's one of the hardest, I think, of the biopharma kind of cases to deal with. I note that for all the eager anticipation leading up to the Supreme Court's decision in 2023, when it finally came to it, the Supreme Court described its ruling as just a restatement in the biopharma context of what it had said about the enablement requirements on many past occasions. Namely, that if a patent claims an entire class of processes, machines, manufacturers, or compositions of matter, the patent specification must enable a person skilled in the art to make and use the entire class. Now, Amgen was not
a case brought under the traditional way that we typically think of biopharma cases coming up in the United States. It wasn't a Hatch-Waxman case. It wasn't even a case brought under the Biologics Price Competition and Innovation Act, the BPCIA. It was brought under traditional patent statutes. But I do want to take a moment to talk about the BPCIA because that statute was passed in 2010 as a way of providing an abbreviated path to approval of biosimilar products. It would be akin to the path available for so-called small molecule generic drugs under the Hatch-Waxman Act. My dear friend, Judge Rader, I think was probably around in Congress or when they were drafting the Hatch-Waxman Act. And that was the product of very careful legislative balancing of multiple constraints and political concerns. And the biosimilars, the PCIA, is a similar effort. Without getting too far into the regulatory weeds or into the science, which, as I already said, would put me instantly out of my depth, suffice it to say that while the analogy is not perfect, biosimilars are biologic treatment products are to biologic treatment products as generic small molecule drugs are to traditional name brand drugs. The big difference is that whereas a generic small molecule drug can be an exact replica of the name brand, a biosimilar can be highly similar to the reference product, but it will never be exactly the same because the complex proteins in biological products are not subject to copying in the same way as small molecule drugs are. This has ramifications when one comes to questions of patentability of the reference product, because although there have not been as many, not nearly as many, biosimilar cases, at least not relative to Hatch-Waxman cases, one issue that seems to predictably come up in those cases, as it did in Amgen versus Sanofi, is enablement. If you know the case of Amgen versus Sanofi, you'll remember that Amgen sued Sanofi for infringing a couple of patents that Amgen had obtained on antibodies that affect the level of so-called LDL cholesterol. That's the bad cholesterol that contributes to risk for heart disease and stroke. The suit was brought in my home district of Delaware, which, as you've heard already mentioned in this conference, sees a whole lot of patent cases. And while my usual gig is on the Third Circuit Court of Appeals, I sit regularly as a judge of first instance in the District of Delaware so that I can continue to keep my hand in patent cases. And one of my colleagues handled this on the district court. The patents claimed a genus of antibodies affecting the PCSK9 protein. In other words, as the court put it, the PCSK9 is a naturally occurring protein that binds to and degrades LDL receptors. And that can pose a problem because the body produces LDL receptors specifically to perform the beneficial function of getting rid of LDL cholesterol from the bloodstream. So in the claims at issue in the case, Amgen did not seek protection for any particular antibody described by an amino acid sequence. Instead, it purported to claim for itself the entire genus of antibodies that bind to specific amino acid residues on that particular protein and block that protein from binding to LDL receptors. And that presented a problem. I'm greatly simplifying here in the interest of time and my own limited knowledge, but the problem was, given the variety of permutations that the antibodies could manifest, there could be millions of them that fit the parameters of the broad claims in the patent. This sort of patent claiming typically is, I'm gonna focus on the antigen that's the target of the antibody. I'm gonna focus on the function that I want this antibody to perform and where it's going to perform it on the protein. And I'm going to then claim a broad genus kind of a claim against all the antibodies associated with that. And that's what Amgen did there, but it provided only 26 examples of specific antibodies. Without putting words into the Supreme Court justices' mouths, I think the justices saw this basically as if someone tried to claim 1 million acres of land with a deed describing just 26 acres. The Federal Circuit had looked at the dispute and held the asserted claims were not enabled, and the Supreme Court agreed with them. It said that, quote, the specification must enable the full scope of the invention as defined by its claims. The more one claims, the more one must enable. That principle was brought to bear again in a case just last year in the Federal Circuit called Basalta versus Genentech. It was another antibody case, and the court there observed that the facts were materially indistinguishable from those in Amgen. So it's not surprising that the outcome of the case was the same, since there were, quote, millions of potential candidate antibodies and the written description disclosed only 11. The court then held that the claims were not enabled and hence were invalid. As the Federal Circuit put it, it is undisputed that to practice the full scope of the claimed invention, skilled artisans must make candidate antibodies and screen them to determine which ones perform the claimed functions. Under Amgen, such random trial and error discovery without more constitutes unreasonable experimentation and so falls outside the bounds required by written description. So that's that. Now, in the no time I have left, I'll mention these three patents, potential pieces of litigation, because they could be important in the U.S. and perhaps to other countries as well. The Patent Eligibility Restoration Act aims to resolve uncertainty over patentable subject matter. It's been an object of a lot of dispute and argument in the United States, what can and can't be covered by patents, ever since the Supreme Court's decision in Mayo Collaborative Services, a biopharma kind of case, by the way. So that would be a big deal if they manage the Congress to tackle this, because the Supreme Court won't. Second, there's the so-called Prevail Act, which, according to the legislation, would do a number of things to alter how the PTAB, the Patent Trial and Appeal Board, operates, including making some standing requirements in that body which have not existed before now. That is, standing to bring a post-grant or IPR challenge. And finally, maybe most dramatic, the Restore Patent Acts case, or Act, which would essentially do away with the Supreme Court's decision in eBay versus Merck Exchange, which overruled the long-standing precedent establishing a presumption for injunctive relief upon a finding of infringement of a valid patent. That would be a very significant step, and it has strong bipartisan support, and I'm hopeful that it passes. Thanks very much.
예, 조던 판사님, 예, 감사드립니다.
Thank you so much for the presentation. We'll now move to the next presentation, which will be from Judge Mead, and he's going to talk about insufficient requirement, inventive step requirement, and cases in the UK law related to plausibility dispute related to this requirement. Please go ahead.
Thank you very much. Could you put the slide up, please? Thank you very much. So I'm going to talk about the law of plausibility in European patents, both from the perspective of UK law and from the perspective of EPO, European Patent Office case law. And I'm also going to talk about the way in which our courts in the UK try to follow the case law of the EPO, where it establishes new principles or where it changes established principles. The law of plausibility in European patent law isn't exclusively applicable to the pharma field, but that's where it really has its effect, and that is where it is of topical interest. So I'll start with the case of Warner-Lambert and generics from our Supreme Court in 2018. And this is the equivalent case to the case in Japan that Judge Amano discussed already. And it had the same result as was achieved in Japan, as I understand it, for very similar reasons. It was a second medical use claim for the use of the known drug pregabalin in treating neuropathic pain. And on the facts that the trial court had found, the patent said that pregabalin was useful for treating neuropathic pain, but it didn't contain any evidence, any reasonable evidence anyway, that that was in fact true. And the question for the court, and in due course the Supreme Court, was whether or not that rendered the patent invalid. For reasons I'll come on to, our Supreme Court in that case reviewed all of the European Patent Office case law on this topic, and it opted for what at the time was called the ab initio plausibility test. And that was one of three tests that had been considered by the European Patent Office over the several years before that decision. And what the ab initio plausibility test means is that where a patentee seeks to rely on a particular effect, in this case the use of pregabalin to treat neuropathic pain, then in order to rely on that effect, either for the law of inventive step or for the law of sufficiency, the specification has to contain some reason to think, some evidence-based reason to think, that the effect is in fact achieved. The Supreme Court said that it was a low hurdle, an easy hurdle to clear, but that there had to be some reason to think the effect was true. And that could be based either on some simple experiment such as an animal model, or it could be based on a rational theory, even in the absence of some experimental material. So that was the situation in the Supreme Court decision in the UK. The next important event was the decision by the enlarged board of the European Patent Office. Goes without saying, I'm talking here now about the European Patent Office and not the UPC, in the case of G2 of 21. And the enlarged board of the EPO is the European Patent Office's ultimate court, the highest court of appeal. It hears only a few cases, it hears only the most important cases, and it can take cases either because a lower court refers them or because the president of the European Patent Office refers a case for decision. The decision in G2 of 21 was mainly a case about inventive step, which is decided for us under Article 56 of the European Patent Convention. But it contained obiter comments, in other words, comments that weren't essential to the decision, about insufficiency, which arises under Article 83 of the EPC, and especially insufficiency of second medical use claims. And the case appeared to treat insufficiency differently from inventive step. The court said in its decision that plausibility was not a separate legal concept recognized by the European Patent Convention. And in fact, the UK Supreme Court had said the same thing in Warner-Lambert and the pregabalin case. And it went on to say, the enlarged board that is, that inventive step is essentially a disclosure test so far as the EPO is concerned. And what I mean by that is that it is sufficient for a claimed technical effect to be taken into account for the law of obviousness, that the effect is disclosed in the patent application, even if the patent application doesn't contain any evidence to justify thinking that it's true. In other words, it's enough for the patentee to say that the effect exists. In respect of second medical use cases, in its obiter comments, the enlarged board said that where a technical feature is recited in the claim of the patent, which is typically the case with second medical use patents, then there does have to be some reason in the specification to consider that the effect is truly possessed. So that was the position from the case law of the EPO following G2 of 21. And you will have noticed, I'm sure, that there was a potential difference between the EPO case law and the UK case law, at least in respect of inventive step. So the next question for us in the UK is, how should we proceed in the light of EPO case law? And I've put 4 propositions here. First of all, the UK courts will normally follow the settled case law of the EPO, and certainly a decision of the Enlarged Board of Appeal is the settled case law of the EPO. However, second point, the UK courts apply the doctrine of precedent. The UK Court of Appeal has decided that it can depart from the effect of its own decisions, which would normally be binding on it, in the event of later EPO case law which is different. But it's been decided by the UK Supreme Court, only the UK Supreme Court can depart from its own decisions in the event of later EPO case law. So until our Supreme Court reconsiders Warner-Lambert and the pregabalin case, that will be a bit binding decision for us. Next, the Court of Appeal had to consider how to apply these propositions in a case called Sandoz and Teva against BMS, which concerned a drug called apixaban. I think Judge Calden mentioned it earlier. And the Court of Appeal, in the context of a single molecule claim, held that there was no need to change from the Supreme Court's case law in Warner-Lambert. Indeed, of course, the Court of Appeal wasn't free to do that because Warner-Lambert was binding on it. And following a further detailed review of the EPO case law, the Court of Appeal in apixaban said that the EPO decision in G2 of 21 was rather the same as ab initio plausibility, which I think later cases in the EPO itself has turned out to show was not correct, but the Court of Appeal was making these statements at quite an early stage. So the Court of Appeal held that the patent was invalid. A different decision has been reached in the Netherlands and indeed a number of other European jurisdictions, and that's why this remains such an important topic. Just to emphasize, it wasn't a material difference between apixaban and Warner-Lambert that there was a claim to a single compound. That was the same in both cases. And in the apixaban case, the Court of Appeal had noted that the parties had said that the case would be decided the same way, whether it was decided for inventive step or insufficiency. And that is doubtful now in the light of G2 of 21, but the Court of Appeal couldn't depart from the way in which the parties had agreed that the case ought to be decided. The Supreme Court, for us, refused permission to appeal in that case, to the surprise of quite a lot of lawyers in the field in the UK. But it is the Supreme Court's own decision in the UK, and only the Supreme Court's decision, what cases to take on appeal. And it's widely thought, and I agree with this, that the Supreme Court in that case probably thought that the decision was too fact-specific and not the right occasion for them to reconsider the law in general. So for us, the important questions that we will have to face in the near future are these. First of all, when the UK Supreme Court comes to consider G2 of 21, as I'm sure it will, because it knows it's the only court that can change UK law, what will it do? Second, how can speculative claims be policed? And what I mean by a speculative claim is a claim where a patentee in fact has no reason to believe that an effect is true, but simply asserts that it's true and uses that as the basis for a claim. It's unclear in the light of G2 of 21 how those situations should be controlled. Thirdly, and relatedly, how should the law of insufficiency under Article 83 of the EPC be assessed in the light of G2 of 21? That's an open question for reasons that I discussed earlier in touching on that case. And fourthly, also importantly, should it matter to the law of insufficiency whether the technical effect is actually recited in the claim or not recited in the claim but relied on in the specification as the basis for patentability? So this is a fast-changing area. There will certainly be new case law to come from the UK, and I suspect the European Patent Office, probably the UPC as well in the near future, and I look forward to seeing what is decided by those courts. Thank you very much.
예, 미드 판사님.
Well, thank you very much, Judge Mead. Next, we'll move
일부의 마지막으로
to the
이지영 판사님의 순서입니다.
Judge Ji-young Lee's presentation. It's going to look at the Korean cases where they look at the sufficiency requirement and inventive step requirements.
판사입니다.
Hi, this is Lee Ji-young. I don't have not much time, so I will just focus on a few cases. And before I move on to the cases, I would like to share my personal thoughts. As you can see from my CV, before I studied law, I studied pharmaceutical area, and back in the days, I thought that I would be saving the humanity by studying the pharmaceutical area, and I did go through the master's and the doctoral degree, and the imitative, its development, I did make contributions and efforts towards it. But then as I became the judge, ironically, I am killing a lot of the pharmaceutical patents. So this is a very ironical situation. But in one other way, the civil judges and the criminal judges, they are always thinking about, maybe they're harming one's lives. And then when the judges deal with the patents, maybe we are, killing or making a decision on the, drugs that may be saving, a lot of lives. So we are always trapped in this very serious question in mind, and we, I believe, are sharing the same kind of a difficulty in that sense. And let me start my presentation with that note. And when it comes to the Korean context, when it comes to the enablement, I am sure that many of you are very well aware of this concept, so I'll be just touching upon really just a few points. And when it comes to the pharmaceuticals, the mechanism of the drug is the most important, and if it is clear, there's no problem, but then if it is not clear, then the examples will need to be provided, or experimental examples will need to be provided. And in the specifications, you cannot supplement it afterwards, so this is rather strictly looked at. So when it comes to the data that can be substituting that can be supplemented by the experimental data, what would that be? That could be encompassing both the qualitative and quantitative aspects. And the UK and US's plausibility, just like that, we are not only looking at, we are not including all of that aspect in the Korean context. We are still having some disputes around whether to include that aspect or not. But then I think I can give you the Abilify case as an example. As you can see, the first medical use was the unipolar depression, depression. But then the depression from the bipolar disorder, can that be also treated using this medicine, is something that was at issue. And the Supreme Court looked at the drug mechanism as a starter, and if there is no such information, it looked at the data of the medical pharmacological data, and it also looked at the pharmacological effect. And as mentioned earlier, the unipolar depression and the depression from the bipolar disorder are two different diagnoses, and the treatment methods are different. So even when you have the effect that is verified for the first one, it doesn't mean that it can be applied to the second one. So they are diagnosed and treated differently. So that was not specified in the specifications. So even if you don't have the pharmacological data, maybe there could be some description that could be, substituting such description, and there was none. That is why the patent was rendered invalid in this case. And when it comes to the medical use inventions, I mean, maybe the bar seems to be very high, and that may be the criticism that many judges receive. But then this area requires further academic research. And let me move on to the inventive step. And as for the inventive step, as you can see, we have the definition set out in the Article 29.2 of the Patent Act. And when it comes to the inventive step, I mean, the Supreme Court have made multiple rulings related to it, and I have quoted in the page. So based on this kind of a criterion, if the Fusita can form the item with the prior art, and if that can be made easily, and if the same effect can be achieved, then that would be the inventive step requirements that will need to be looked at. And there are two major cases that I would like to touch upon related to this. So this is the imatinib case. I mean, the tyrokinase inhibitor, the receptors that are working at the cells is something that is at issue here. And Gleevec, the leukemia treatment, the leukemia drug, is at issue. The first one is the Gleevec. And the second medical use is related to the autoimmune disease, which is the GIST, and that was registered as the patent is registered for the second medical use as well, and there was a validity proceedings, and the IP High Court said that it is a patent because of the inventiveness, but then the Supreme Court held that it is invalid because it lacks inventive step. And as you can see, Gleevec does have the c-KIT genes, and it is inhibiting the activation of the c-KIT gene that is in the prior art. And the c-KIT gene, if there is an abnormal activation there, then it causes GIST, and that is a known knowledge. So from the Fusita's perspective, the Gleevec is related to the abnormality of the c-KIT, and the c-KIT's abnormality is related to the GIST patients. So it could be actually considered like the ladder logic. And if you attach these two different logics, I mean, it is quite easy to come to the same conclusion. So the Supreme Court denied the inventive step of this invention. And there is a rather more complex case that's related to the pregabalin case, and we talked about it from the Japanese case and the UK case, and that was about the second medical use, and you talked about the specification requirements, but then in Korea, the key question was around the inventive step. So the inventive step was acknowledged in Korea, and the validity was maintained. And due to the time constraint, let me be very brief in explaining this. So the pregabalin is the patented invention, and there was a prior invention, which is the lasemiche. And as you know, lasemiche is like a mirror image. So the formula is the same, but then it is a mirror image of the original one, and the combination between the two is the lasemate, and one of it is considered the S isomer, and the other one I believe is a P isomer or something. And the prior invention was the two being combined together, and the patented invention was the two apart. So the structure is quite similar, but then there is a known information from the prior invention, which is GABA level. I mean, GABA GABA levels of the brain, if it goes up in the brain, then it would have the antispasmodic effect. You will have the calming effect on your body. And secondly, it will reduce pain. So when the GABA levels go up, these two effects would be in effect, and the plaintiff argues as following. So the pregabalin is based on lacemate, and that increases the GABA level, and when the GABA level goes up, then it will have the antispasmodic effect. That's the prior invention. And the second prior invention is GABA level goes up, then the pain will be reduced. Then the lacemate increasing the GABA, that's one, and GABA treating the pain, that's the second. And if you combine the two, then that's a very simple logic. I mean, pregabalin would naturally have the pain relieving effect. So that is like the GIST, case that we saw, and you may think that this is very similar to the earlier case, but then the Supreme Court ruled otherwise. First of all, lacemate increasing the GABA levels. The Supreme Court looked at other prior documents, prior literature, and it was not the case. To increase the GABA level, the GAD enzyme had to be activated. And we tested it at the cell. You increase the GABA level there, and when you connect it to the GE, then the effect was GAD, then it was not as active. So GABA level increase, is that really natural? I mean, that was still doubtable. So lacemate having the antispasmodic effect, maybe not, that is not because of the GABA level increase. Then the three-level logic gets collapsed, and that is why the Supreme Court held that even though the GABA level has something to do with the pain treatment, maybe that GABA level is not directly related to the pregabalin. It is not clear, so that is why the inventive step is not denied. And I will be able to talk about this in more detail at dinner time, but the three-step logic was not applied in this particular case, unlike the earlier one. And I would like to share with you two other cases from the Korean Supreme Court. And the Korean Supreme Court, when it comes to the selection invention, I mean, it talks about whether the combination is easy and how much of the effect it has. So the difficulty of construction or difficulty of the combination is something that they look at, but then for this one, they don't look at it for the selection invention, because when it comes to the selection invention, it's about selecting from a wider pool. So selecting may not be so easy, may not be so difficult. So the combination is not that easy. So it was only using the inventive, the other criteria to judge the inventive step. But then when it comes to the Apexaban case, it changed its view. It started to see that selecting from the pool in and of itself can be difficult. So in the prior art, to make it into an apixaban, A, B, D, G, I mean, we have many different factors there in the screen, and when it comes to the combination, a lot of myriads of combination would be going in that could actually result in like millions of combinations. And the Fusita, if that person is doing the trials and error, it will take a long time, and even if you're using a computer, it will still take a long time with a lot of difficulties. So even when it comes to the selection invention, you will not only look at the effect, you will also need to consider how many trials and errors one would need to go through and how difficult it is to make that combination. And that's sort of a legal, doctrine, or the legal principle started to be emerging in the Korean context as well. And another one is around crystalline invention or polymorph invention. It's like this, boiling the sugar. If you continue boiling it, it becomes like the crystal, and then it will melt, and then it will become crystals afterwards. And identifying a structured or crystal-formed material from that kind of a process is something that is related to this type of an invention. And in the past, the difficulty of composition was not really looked at in the Korean court. But then, even when it comes to the crystalline form invention, whether it is easily achievable or not is something that will still need to be looked at separately and thoroughly. And that was a change that took place in the Korean court. And I did, lay out some details in the booklet. But if you have any questions, among the panelists, then I would be happy to talk about them separately afterwards. Thank you.
예, 이지영 판사님.
Well, thank you for that presentation. With that,
3세션에
and we would have heard all the presentations as part one, and part two is Q&A session. To one panelist, the remaining 5 panelists will pose questions, and we'll listen to the answers. We have actually passed a lot of allotted time. But so for the efficiency, we have already collected questions and distributed to the panelists already. So the questions will be put on the slides, and panelists on the prepared questions, if you could give a group of answers for 5 minutes, it would be appreciated, and then we'll get questions from the floor. Now, starting from Judge Amano, we have already sent you the questions, so we will give you 5 minutes. So please give overall answers to those questions, and we will pop the question up on the screen. Thank you.
Okay, just quickly, from the question from China, I already explained that the screening for monoforms are considered as a routine for the skilled person in the art. So generally claiming up some sort of Christian is not have inventive steps. So just the kind of difficulty or effect is needed to get an inventive step. The next question from UPC is that about how we find the accused substance used for the patented use. It is very difficult. Therefore, in Japan, especially in pharmaceutical industry, courts tend to look at the package insert or a product monograph issued by Ministry of Public Health. It is called a label theory. When there is enough evidence that the defendant does not follow the instruction written in the package insert and uses the substances mainly for the patented use, the court may find infringement. Next question from USA about the recent change about enablement requirement. Although there are not any changes in enablement requirement, but striking a balance between patent protection and access to technology. IP High Court had welcomed many amicus briefs recently in the case where the Doctors Act or drug compounding is accused for patent infringement. The issue is the scope of Patent Act clause, which exempts doctors' liabilities. It is said that in Japan, there are not enough protection for doctors from patent infringement suit. So this case will be a trigger for the argument whether doctors should have more protection. From the question from United Kingdom, theoretically, if the products or compounds have survived the scrutiny of novelty or obviousness, the claimed product or compounds are protected as themselves. So the Japan Patent Office does not require applicants to claim up its inventive contribution to a claim if the claimed product is useful, novel, and non-obvious. However, in most cases, the examiner makes first action of refusal for novelty or obviousness for inventions for compounds itself. For the question from Korea, for the secondary use inventions, Japan Patent Office requires at least one working example supporting medical use. As I explained in the Warner-Lambert case, to clear support requirement and enablement requirement, applicants sometimes have to disclose enough examples which enable skilled persons to understand that the secondary use is really effective and could solve the problem. I didn't find any criticism to this practice. That's it.
예, 아마노 판사님, 예, 감사드립니다.
Thank you very much. Now, moving on to Judge Fu. Again, 5 minutes, please. So all the questions that you have received, if you give collective answer, thank you.
Okay. The first question is from Japan. And this question is for my second case. Regarding a fast-track channel, currently, there's no relevant expedited processing procedure in China. If the patent's validity is later upheld, the patent holder can still file a lawsuit and get protected accordingly. And the second question is from UPC. I indeed cannot predict whether an anti-suit injunction will be issued in the field of SEP, as it depends on the specific circumstance of Chinese law and its judicial practice. And next question is from USA. My answer is yes, as you mentioned, chemical compounds cannot obtain utility model patent rights, but equipment used in the manufacture or processing of pharmaceuticals can be protected as a utility model patent. And next question is from UK. If a pharmaceutical patent is valid and infringed upon, the court should analyze whether the plaintiff claims can be supported. For method patents or product patents in the field of pharmaceutical, the content of the injunction may vary, as they protect different kinds of technical solutions. And the last question is from Korea. Before this amendment to the patent law in 2020, China already had patent validity confirmation lawsuit in patent litigation. This pharmaceutical patent linkage litigation introduced confirmation lawsuit into the specific field of pharmaceuticals. Thank you.
네, 푸 판사님, 예, 감사드립니다.
Thank you very much. Now moving on to UPC's Judge Hedike. Again, 5 minutes. If you could answer all the questions together, which you have already received. Thank you.
I read in my travel guide that Korea is famous for very good new glasses. I should have taken the advice and bought new glasses, because now I cannot really read the questions, but I can guess the questions. I remember them also. So thank you for the helpful. Okay. So I think some of the questions focused on the problem-solution approach, and as I said in my presentation, it's still open which approach we take. I can maybe give a very brief overview of the differences between the problem-solution approach and the German approach. The problem-solution approach identifies the state of the art within the invention and looks at the document which is closest to the invention. And the German approach defines the problem in a more open way. It is not determined with a view to the invention. The approach determines the technical problem and does not mean to compare it with the solution. So the starting point is different. What are the differences? Well, they are not so big as one might think, because the German law requires for inventiveness that there's a pointer in the state of the art next to the EPO applies the could-would approach, which also requires promptings. What are the differences then? There's a certain danger that the EPO approach uses hindsight in determining the state of the art. The technical problem of the EPO is more difficult to be formulated in such way to avoid that certain elements of the solution are already implemented. And maybe the German approach is also more open in the sense that the problem is formulated in a more general way. It is not narrowed in the sense that there would be a technical problem which requires a technical solution. So the problem could be vaster and could be diverse, maybe to make the product more attractive or more marketable. And finally, the German approach reflects the situation of the inventor, who does not necessarily know into which direction the invention should go. But these are dogmatic differences. In practice, as I said before, I think the differences are not that big, and there are where we need to wait and see how things develop in the UPC. I can't say anything more about that. What issues have emerged during the rollout of the Unified Patent Court as pharmaceutical patents have been addressed? Well, I think we don't have so much special pharmaceutical patent issues because we have these 2 or 3 cases, and I talked about those. And I can use this opportunity to make publicity for the Hamburg division. Judge Klepsch has a chemical background, she's a chemical engineer, so we are certainly able to deal with chemical patents. The problems we have, I think, are more of a general nature, like the case management system is a problem, and we need to establish and get our things together there too. I think Judge Lee's decision, our question, I already answered it because for the proper solution approach. And let me see. I think I'm through with the questions. I think that's it. Thank you very much.
Well, thank you very much, Judge Hedike. Now we'll move on to Judge Jordan. Please.
Okay, thank you. Beginning with Judge Amano's question from Japan. He asked, in the Restore Patent Rights Act, are there any added requirements to get an injunction? And the answer is no. But I think it's important to note that the aim is to the contrary. It's to try to make getting an injunction easier, not harder. And if they're successful in getting that passed, that will restore, as you might notice, by the way, that it's a habit in the United States for Congress to try to come up with clever acronyms. RESTORE stands for Realizing Engineering, Science, and Technology Opportunities by Restoring Patent Rights Act of 2024. Yeah, all of that to try to say, restore. We want to get back to pre-eBay law. What are the chances the bill will get passed? Boy, that's so hard to say, but I will tell you that this has got more bipartisan support than most any legislation in the patent arena that I can think of in the last several years. There's lots and lots of support on both sides of the aisle for getting it done, so I'm relatively hopeful that that one will get passed, and I don't think that the presidential election will affect the fate of that bill either way, because I don't think either it's not really a Democrat or a Republican issue. Judge Heideke asked, do you expect consequences of the presidential election on pharmaceutical patent law? And the answer is, yeah, probably not. It's a little difficult to say, but these are the dividing line really in the U.S. Congress, I think, and I don't pretend to be an expert on this either, but I think the dividing line is probably the same as it is in many countries, and that's between the technology industry's interests and the pharmaceutical industry's interests. They have very different takes on how stiff they want the patent laws to be, and that's not so much right or left as two strong and well-heeled industries lobbying Congress. I would say that historically there's been more interest in the Democratic Party, more willingness to give directions to pharmaceutical industry or to tech industry, then there's been maybe an appetite on the Republican side. But the party's positions on these things are in flux as there's a great realignment underway in the Republican and Democratic parties in the United States. In what sort of circumstances, Judge Mead asked, might it be likely that injunctive relief would still be refused under the Restore Patent Acts? And I'm guessing that the answer to that is in a case much like the one that motivated the eBay case to begin with, and that is you've got a non-practicing entity, a patent assertion entity that's pressing its rights with respect to a patent that has very significant publicly significant effects. You could see that happening with a drug. You could see it happening with at the time, a BlackBerry, an important technology patent. I could see something like that coming up again. And finally, Judge Yee asked, and I hope you've had a chance to read this. It is a detailed and important question, but it gets to the issue of what had been called the antibody exception in the Patent and Trademark Office with respect to whether or not you could get a broad genus claim with functional claiming. And the Patent Office had said, well, you could do that with antibodies because there's really we don't really understand the structure very well, so go ahead and do it that way. That was sort of the gist of it. And that got deep sixth. The Federal Circuit really tightened up the enablement requirement with respect to biopharma patents, maybe with the Lilly case back in the late 90s, and then with the Janssen AbbVie versus Janssen case back in 2014, I think it was, and they did that on the basis of written description, not on the basis of enablement. And then tightening up things on the enablement side in Amgen versus Sanofi, which, as I've said, the Supreme Court went ahead and affirmed. So, yeah, that's gone, and I don't think that antibody exception is coming back. There's not a real good answer to that right now. This is going to have to get worked out over time. If we had more time, I'd be interested to have a discussion on this panel or with any of you about how to get the right balance between requiring more in the way of enabling disclosure and not wanting to clamp down on a field of art which has such promise, and it is so difficult to give the kind of structural disclosures people are used to getting. That's not an easy set of tensions to navigate.
예, 조든 판사님.
Well, thank you very much for that answer. Now we move to UK. Judge Mead, you have the floor.
Thank you very much. Judge Fu and Judge Yee have asked related and overlapping questions. Judge Fu asks about the differences between UK law and EPO case law and how we balance them. And Judge Yee has asked a question about G2 of 21. And I've touched on quite a lot of this already in my main presentation. We try to balance these differences by ultimately following EPO case law as closely as possible whenever we can. But those decisions have to be made where it involves changing UK case law, either by the Court of Appeal or by the UK Supreme Court. And I'm a first instance trial judge, so as the expression goes, these questions are above my pay grade. They will have to be resolved by the appellate courts. I would say this, one difference, cosmetic difference between the UK and the EPO is that we don't use the problem solution approach. But our case law has consistently said that there should be no difference in the result between the approach we use and the problem solution approach. And the EPO adopts the problem solution approach for practical and procedural reasons, partly. And both the EPO and the higher UK courts have all said that the ultimate statutory question is simply whether the invention is obvious under Article 56 of the EPC. So it's important, I think, to notice that some of the differences between the UK and the EPO, or indeed the German courts or the UPC and the EPO, are more presentational than real. And it would be a disappointment to us in the UK if we ever found ourselves in the long run applying different law from the EPO. We very much want to be the same, and in due course, I'm sure, albeit in a slightly different context, we will be giving very close and careful attention to appeal decisions from the UPC. Judge Heidecker asks a question by comparison with the UPC Munich Local Division in 10x Genomics about the standard of proof applied by the UK courts for the grant of a PI, a preliminary injunction, an interim injunction. And he asks whether we apply the preponderance of evidence test. The answer is that the UK courts don't apply the preponderance of probability test for interim injunctions. For final injunctions, for final trials, we make our decision based on the ordinary civil burden of proof, more likely than not. But for interim injunctions, the UK simply determines whether the patentee has an arguable case and whether the defendant has an arguable defense. And if they do, then we decide whether or not to grant an interim injunction based on the balance of justice, which is probably a familiar concept to you. But what I mean by that, just in case there's some issue over the translation of the language, what I mean by that is the court asks itself, if I grant an injunction and then it turns out at trial that I should not have done that, can the defendant be compensated? Or correspondingly, if I refuse to give an injunction and then it turns out at trial that there should have been one, will justice be done, can justice be done to the patentee? So for interim injunctions, the balance of the burden of proof is not very important, and it simply requires that there's an arguable case on both sides. And then lastly, Judge Jordan asks, in the US there are occasionally antitrust claims brought against pharma companies for patent thickets, and do the UK courts have similar cases? The answer is, in the European regime there are similar situations, for example with pharma companies deliberately misleading the patent office to obtain a patent to prevent generic entry, or in one instance by manipulating the patent owner's own marketing authorizations to delay generic entrance. And in both those situations, which in fact arose in the same case, the pharma company was fined a very large amount, in the hundreds of millions. Those are not claims that have generally been litigated in the UK courts as private claims. They've been antitrust investigations by the competition authorities in the EU. Post-Brexit, our own competition authorities have the power to do that, and I'm sure will in the right case, and theoretically there could be a private law claim, but actually it's very rare, and certainly very rare for them to be successful.
예, 미드 판사님, 예, 감사드립니다.
Thank you, Mead. And lastly, I would like to ask Judge Yi to go ahead with her answers.
일본 판사님 질문에 대해서는 구성의 곤란성만으로 진보성을 판단한 결정형 사례는 없습니다. 그래서 타일로시 판결 이후에 선고되었던 대법원 판결인 셀렉스팍 1형이나 미라베그론 알파형 결정의 진보성에 대해서도 구성의 곤란성뿐만 아니라 현저한 효과 여부까지도 함께 판단했다라는 점을 말씀드리겠습니다. 중국 판사님 질문에 대한 답변으로는 이제 청구 범위라든지 특허 청구 범위에 맞는 데이터인지를 확인하는 방법은 결국 당사자들의 주장과 당사자들이 제출한 증거에 의해서 판단할 수밖에 없는 것 같습니다. 일방 당사자가 낸 증거에 의한 청구 범위를 인정할 수 없다라고 한다면 그걸 주장하는 당사 반대쪽에서 합당한 반증을 제출을 하면 되는 것 같습니다. 관련해서 당사자의 주장과 증명만으로 부족할 경우에는 민사소송법과 특허법이 규정하는 뭐 전문가 증인 제도나 감정 검증을 통해서도 확인이 가능합니다. 실제로 특허 사건에서 직접 재판부에서 검증을 통해서 이것이 효과가 있는지 그 권리 범위에 속하는지를 판단했던 사례도 있다고 저는 들었었습니다. 그래서 그런 방법으로 판단이 가능하다라는 것이고, 또 제출된 데이터의 신뢰성에 대해서도 같은 방식으로 확인이 가능한 것 같습니다. 그리고 데이터가 조작이 되거나 뭐 위조 변조된 사례는 사실은 거의 없었던 것 같습니다. 일단 제출된 증거 자체는 거짓이 없으나 그 증거가 주장과 합당하느냐의 문제만 남기 때문에 결국은 법관이 자유심증으로 판단할 사안이라고 생각을 합니다. UPC의 질문에 대해서는 이게 한국에서는 뭐 매니피스트 어레인지먼트라 불리는 법리는 없긴 합니다만 2차 용도에 대한 권리 범위 파악은 굉장히 중요한 문제라서요. 그래서 한국에서도 이와 관련한 프레가발린 침해 사건이 있긴 합니다. 그래서 이게 이제 잘 아시다시피 풀 라벨과 스키니 라벨의 문제입니다. 뭐 한국 발음으로 라벨이지만 뭐 번역하실 때 레이블이라고 해주시면 될 것 같고요. 그래서 결국은 그 용도 특허에 대해서 2차 특허는 유효한 것이고 1차는 특허 효력이 없다고 하면
If there is no such a thing, then in terms of the generics, I mean, the first medical use only would be registered for, and on the label as well, only the first purpose will need to be put in, and using the skinny label to confirm the relationship related to the rights is something that we do. And when it comes to the skinny label, I mean, the infringement was not acknowledged in the full label. I mean, this infringement was acknowledged, and we do have such a case. So even when you receive the label, excluding the patent claim, I mean, if the doctor uses it for the second use, I mean, can we actually hold the pharmaceutical company liable? I mean, in Korea, it is structurally a bit difficult because in Korea, the prescription is based on the product name, not based on the substance name. So the same substance used for other purposes is not easy. And second thing, I mean, you can also use the item authorization system, and if you don't use that system, the doctor cannot be paid. That is based on the national health care or national health insurance system. So there is not many cases where the doctor would be intentionally using the substance for different purposes. And to answer the question from the US, I mean, we did deny the AI as an inventor through the Davos case decision, but using the AI for the development, I mean, that is widely used in the private sector based on my knowledge. So when they are identifying the second medical use, I mean, they would usually in the past conduct the direct cell, diagnosis and stuff like that. But then these days, I mean, they're using the in silico docking and other methods to identify the second medical use. But when they are filing for patent, how much of the specification writing should be done would be an issue, because the device that you use will need to be written down in the specifications to find the second medical use. So when it comes to the AI-based pharmaceutical R&D, I mean, we do not have many projects in place, but then recently the patent office in Korea started making research about this, so we will be able to see the results of such studies in Korea as well. And the last question from the UK, imatinib GIST case was mentioned earlier, and there is a clear statement from the Supreme Court. The effect of the treatment, if that can be easily predicted from the prior art, then regardless of the clinical trials, the inventive step would be denied. So the success rate of the clinical trials and the inventive step are considered not related, and I think the hurdle was considered low in that case. Thank you.
이정 판사님, 감사드립니다. 이로써 저희 세션에서 준비한 공식적인 발표와 답변 순서를 모두 마쳤습니다. 패널분들께 감사드립니다. 저희도 조금 힘이 빠지고 이제 저녁 먹을 시간이 돼서 다들 피곤하신 것 같은데 박수 한번 부탁드리겠습니다. 그러면 혹시 뭐 시간이 많이 지났습니다. 저희가 늦게 15분 정도 늦게 시작을 했기 때문에 저희가 예상 시간보다 조금 늦었고 지금 거의 뭐 약간밖에 안 돼서 늦었습니다. 뭐 어쨌든 시간이 많이 부족하지만 혹시 플로어에서 오늘 그 각국에서 오신 패널분들에 대해 발표 내용에 대해서
If on the presentations, if you have any questions, although we are behind schedule, we'll be more than entertain any questions that you might have because we finished all the official proceedings that we had. And the applause was to encourage the panelists for staying until the end, and that you must be tired. So no microphone because there seems to be a question from the floor. Maybe Judge Han, you could deliver the microphone to the one that want to ask the question.
Thank you for the enlightening speeches. I'm sorry. I know that everybody is tired, but I was so desperate to ask this question. I want to pose a question to Honorable Judge Jordan on Amgen versus Sanofi case. Actually, I read the case right after it was published, and it was with my colleagues in IP High Court. And afterwards, I read numerous articles and comments blatantly blaming this decision. Like, for example, saying cataclysmic shift or two-bladed Fujita killing innovation, assuming the less skilled Fujita in prosecution phase and at the same time omnipotent Fujita when invalidating patent. And it seems that from outer, and you've mentioned on Restore Patent Rights Act, and it is getting bipartisan support. But I wanted to ask what the atmosphere is like in the court among judges on this this decision, and if whether there is a different perspective in the business. And I want to add one more thing. As a person having extraordinary interest in artificial intelligence, I thought that this Amgen versus Sanofi case could be a useful tool in AI era, because in AI era, generative AI can generate like fake inventions very much, and I think enablement requirement could be the real linkage between the patent, linguistic patent, and the real world. And if you could comment on this thought, or I would be also be thankful if any of the speakers could add on or share your thoughts on this issue. Thank you.
Sure. The decision has generated some controversy because and some of the controversy was of the sort you just mentioned, which is people saying, "Oh, look, you've made it impossible for us to incent into innovation in the biologics space because." Nobody can really talk about the structure adequately in the way they can when you're talking about small molecule drugs. It just doesn't match up. And so you've created, in fact, there's a well-known professor at Stanford named Mark Lemley, and he and another fellow wrote an article last year, I think it was, called the patent, the antibody patent paradox or something like that, discussing this point and suggesting that that the traditional applications of enablement were not adequate to provide the kind of incentive that you want in this space. But there's been pushback on that by other academics and by some practitioners, because they've said, look, the very fact that structure and function are not tightly related to each other in biologics the same way they are with small molecules tells you that if you give broad claiming power, you're going to actually retard innovation. You're not going to incent it. And you know that because they say, and this I take this stuff in and I repeat. I'm in the Justice Scalia camp. I got to learn it all in each individual case. But the assertion is that with very little change in structure, you can have an enormous change in function. And by giving broad coverage, you prevent important advances. And we don't want that to happen. And I don't know how that's going to shake out. I really don't. All you have to do is look at the lineup of the amicus briefs that were filed in the Amgen versus Sanofi case to see that major pharmaceutical companies lined up on both sides of that. I wrote it down because I thought it was interesting. AbbVie, Bristol Myers Squibb, and Merck all came in for Amgen. Pfizer, Eli Lilly, Genentech, and AstraZeneca all came in for Sanofi. And when all those guys can't agree with each other, you know there's an issue, right?
예, 답변 감사드립니다.
Thank you for your answer. I think time is up for today. So this is the end of the session 3. But before we finish, I would like to give maybe 30 seconds to 1 minute to all the panelists to have a closing remark. So starting from Judge Amano of Kenji.
Okay. All right. I'm glad to here today. Thank you for inviting me to the conference and memorial conference of 10th anniversary. When I was very young judge, I was eager to become an IP specialized judge. And in 2009, I went to the United States. And 2011, I went to the federal circuit and go to the then chief judge leader. And I spent several weeks in Judge Rader's chambers. So today, I have the opportunity to speak with former Judge Rader. It was very wonderful time for me to see and speak with Judge Rader. Even though my answer to the doctrine of equivalent is different from his answer, but I was very glad and very nice to come here today. And thank you for very organized conference made by every staffs and judges of IP High Court. Thank you so much.
이어서 중국의 푸 판사님.
We'll hear from Judge Fu from China.
It's my honor to be here. Chinese course place great emphasis on the pharmaceutical and biotech. In this session, I learned many experience and judicial practice from the judges from different countries. I think this will make me and make us improve together. And I am also looking forward to the upcoming session. Thank you.
네, 감사드립니다.
Thank you.
UPC의
Thank you very much. Now, Judge Hedike, please.
I teach a patent law class at my university every year, and at the university, patent law is looked upon as something very strange. Are they really lawyers or are they technicians? Do they know what a contract is and so on? But when I teach this class, each time I tell my students, what we do is one of the most important things at all, because we secure innovation. We are the ones who protect the future, who create the future, because we are the ones who don't protest and are anti-technology, but we are trying to develop life further. And I think this is very, very important, and especially meeting at such a high-level conference, talk about these important things, is something I really, really appreciate. I want to say thank you again for having me here and for having giving me the chance to listen to all these very interesting presentations. Thank you very much.
예.
Thank you very much. Now, let me invite Judge Jordan.
I had the chance to participate in this conference in 2020, but that was the COVID era, and it was just remote. And I just want to say how much more I like being with you in person. You're all a lot better in person. Virtual's good, but the socializing, the chance to visit with you, the food's a lot better in person too. So many, many thanks for the opportunity to participate with you. This has just been a wonderful conference. I'm looking forward to tomorrow.
네, 감사합니다. 이어서 영국의 미드 판사님 말씀.
Yes, Judge Mead, your turn.
Thank you very much. Many of my fellow panelists have said how wonderful the organization of this conference has been, and I fully agree and express my thanks as well. I would say in relation to the two sessions that I've been on, especially how extremely useful it has been to have such detailed materials in advance of the sessions to think about matters before the sessions, and I thought having the questions before this session was especially thought-provoking. I'd also say I'm lucky enough to go to quite a few judicial conferences, and I often am lucky enough to be able to interact with judges from Europe, the UPC, and the US. But this is the first conference where I've had the chance in person to interact so much with judges from the Far East, from Korea, from China, and from Japan, and that has been an especial highlight for me of this conference. So thank you very much to the organizers for those things.
예. 네, 감사합니다. 마지막으로 한국의 이정 판사님.
Thank you, Leslie, Judge Yi.
함께 해주셔서
Thank you so much for being here with us to follow up with the really difficult topic, moderator, panelists, and all the audience members for staying with us until the end. Attorneys and the judges, practitioners.
예, 감사합니다.
Thank you. This concludes the third session. This is an important topic to extend the life of all of us. I mean, of course, patent is really important in that aspect, but then having a great dinner is going to be the most important factor. So let's enjoy lunch now. Dinner now. Thank you.
발표를 진행해 주신
I would like to thank the moderator and also panelists for their efforts. So let's thank their efforts with one round of applause. And with that, we would like to bring the day one program of this conference to end. I would like to thank everyone for staying with us until the end. And tomorrow we'll start at 10. So enjoy your evening, and I'll see you tomorrow. And those that are attending our dinner, we will start as scheduled at 6:40 at this room.